All right, back on the record in the Simpson matter. Mr. Simpson's present before the court with his counsel, Mr. Cochran, Mr. Scheck, Mr. Blazer, people represented by Ms. Clark, Mr. Goldberg, and Mr. Kelberg. Morning, counsel.
Good morning, Your Honor.
We're ready to proceed with Mr. Bodziak?
I'm sure that we are, Your Honor. Could Mr. Blazer and I speak to the court very briefly on a scheduling matter without the reporter at sidebar?
Sure.
Yeah, we need all the exhibits that we had here last Friday. I don't know if they've been brought up. The various boards.
They're on their way.
Okay. Well, when they come up, we'll be ready.
All right, Mrs. Robertson, what's the status of the exhibits? All right, counsel, anything else we can resolve before we have get started with Mr. Bodziak again?
There's a couple things, Your Honor, tonight. In the interest of moving the case along, once the prosecution is finished, I would like to ask the assistance of the prosecution and the court in making the following witnesses available for us. We need Detective Van Adder. We need FBI Agent Martz. We need both Fiata brothers, FBI Agent Michael Wax, W-A-C-H-S, I guess, Deputy District Attorney Dale Davidson, and we need Mr. Gary Sims back. The court will recall that we said we were going to call Gary Sims very briefly on a matter we approached sidebar on, if you recall. Those are the witnesses that we need to have available that I think they have some control over, and we can move quickly to begin the balance of our case and then our rebuttal.
All right, Ms. Clark.
I'm puzzled about Gary Sims, Your Honor. Perhaps that was a sidebar I was not present for. But with respect to Agent Martz, let me indicate this. The witness is Mr. Whitehurst. Agent Martz is irrelevant until the court rules on the admissibility of Agent Whitehurst. And so I think we need to have that motion first. And then, depending on the court's ruling, we will discuss the availability of Agent Martz. At this time, there is no reason to do so at all. If the court will recall, the defense rested conditionally subject to the admissibility of Agent Whitehurst. And Agent Martz has no relevant testimony to give unless and until the court rules on the admissibility of Agent Whitehurst's testimony.
Unfortunately, Ms. Clark, after she promised to be here Saturday, was not here. And we have now talked to Agent Whitehurst, and we have further questions based upon newly discovered evidence of Agent Martz. They can't tell us which witnesses we want to call. We want Agent Martz. We want Detective Van Adder. It's all newly discovered evidence. We want the Fiata brothers. We want Dale Davidson. And with regard to Gary Sims, the court will recall, Mr. Barry Scheck asked the court to allow
I recollect that Mr. Sims was released subject
so that was
to recall.
it. So we, as the court has all said so many times, we have a right to present our case, and we have an absolute right to do that. We have not arrested, and this is newly discovered evidence, and we want to have him out here. Now, if he's our witness, we don't mind paying for him, but we just want to have it facilitated so we don't have any downtime with regard to getting this witness out here.
Your Honor, if I could respond, because I was here both Saturday and Sunday. Mr. Cochran was not here Sunday. Both days were used to interview Dr. Whitehurst. And our position is quite simply, Dr. Whitehurst has a perspective about Agent Martz. And the question is anything that Dr. Whitehurst has to offer relevant to these proceedings?
Well, I assume we're going to take up that issue after we have concluded with Mr. Boziak. I take it this is the prosecution's last witness. All right, then the
So the question is,
defense then has the opportunity to conclude their case, which I assume they're going to do.
but our position with Martz is not to have this man have to fly out here just so we can have a motion that his testimony be excluded until the court rules on Whitehurst's testimony, because if, as we submit...
Let's assume for the sake of the argument, Mr. Kelberg, that there is a possibility that Martz could be recalled for matters regarding the EDTA testing that have nothing to do with Whitehurst. I mean, that's a possibility as well, don't you agree?
Except not for the defense's case, because as I recall the court's statements, the court indicated it was allowing the defense not to rest its case in chief due to this limited area, and that the court would limit it to this area, as a result of which the court said to the prosecution, start your rebuttal. If this is a matter of EDTA, and we have not on our rebuttal, offered anything on EDTA, then their case in chief is...
That's another legal issue.
All right, but the long and short is just the geographics involved. Does Agent Martz have to fly out here to sit until this court rules on Mr. Whitehurst? If we know when, it should be Dr. Whitehurst, if we know when the court anticipates ruling on Dr. Whitehurst, then we can have arrangements available so that Mr. Martz can do his work back at Washington.
Well, counsel, my understanding is that the court reporters will have the transcripts of both Saturday and Sunday's interviews available sometime, I hope, by the end of today. Ms. Moxham is indicating that's correct.
Your Honor, may I just indicate as follows?
So that indicates to me that we will probably, if counsel have the transcripts by the close of business today, that they'll be able to proceed with an offer of proof and argument regarding Dr. Whitehurst probably tomorrow, and we can resolve some of these issues.
Might I just indicate, the reason I brought this up, Your Honor, is the court is aware, those of us who've been here every day in this trial are very much aware of this jury, that we want to get the case to the jury. And I'm trying to
Counsel,
see...
you don't need to tell me that.
Okay. I'm just pointing this out, Your Honor, because of the fact that we have people who don't always appear here. And I'm trying to point out to you, I want Martz here. They can't tell us how to try our case. We want Martz here, and we think we can recall Martz before we ever get to the Whitehurst issue. And so I want to make sure you listen to them, that that's our issue, that we believe Martz should be called first.
As soon as we finish with Boziak, I suspect the people will get up and say, subject to court's permission to reopen if anything else comes up, they rest their rebuttal case. Then focus turns on the defense.
Fine. I was giving you a heads up. That was all it was.
Okay, thank you.
Thank you.
Your Honor, may I be excused?
Don't go too far away, because I don't know how long we're going to have with Mr. Boziak.
I'll be upstairs. I can be reaching Mr. Hodgman's office.
All right. All right, Mr. Scheck, why don't you and Ms. Clark check with Mrs. Robertson and make sure all the exhibits are here ready to go, and as soon as they are, we'll get started. All right? Exhibits ready?
We do, Your Honor.
All right, Deputy Trier, let's have the jury, please. Jury panel, good morning, ladies and gentlemen. All right, Mr. Bodziak, would you resume the witness stand, please? All right, let the record reflect that Mr. William Bodziak is again on the witness stand undergoing cross-examination by Mr. Scheck. Good morning again, Mr. Bodziak.
Good morning.
Mr. Bodziak, sir, you were reminded that you were still under oath, and Mr. Scheck, you may continue with your cross-examination.
Thank you, Your Honor. Good morning, ladies and gentlemen of the jury. Good morning, Agent Bodziak. How are you today, sir?
Fine.
Agent Bodziak, I think you indicated to us on Friday that your knowledge of the extent to which Dr. Lee actually goes to crime scenes and inspects imprint evidence, shoe print evidence, is somewhat limited.
Yes, I stated what knowledge I had about Dr. Lee on Friday.
Are you aware that this Saturday, Dr. Lee investigated a crime scene involving imprint evidence in Kennebunkport, Maine?
Sustained. Sustained. It's irrelevant.
At the request of the FBI?
It's irrelevant.
Now, we left off discussing reasons, I believe, on Friday, that the imprints on the envelope and the piece of paper, in your opinion, could not possibly have come from a shoe.
That's correct.
And I believe we discussed on Friday your views that the non-printing area around the imprints and the lack of a border were factors you considered in reaching your conclusion that it could not have possibly come from a shoe.
That's a part of the factors, yes.
Yes. And I believe you told us that although you recalled seeing 95% of Dr. Lee's testimony, you did not see his testimony about the blood patterns on the envelope and the basis for his belief that the parallel line imprints were made first and other bloodstains were deposited later.
I didn't see that, nor do I believe it has anything to do with whether or not that is a shoe print.
I understand. Now, have you, since we last discussed this on Friday, made any effort to read or review that testimony of Dr. Lee?
No, I haven't.
We also had a discussion at the end of the day on Friday about whether Agent Diedrich believed that the paper and the envelope were probably laying down when something landed on it and made those imprints on it. Do you recall that?
Yes, I do.
All right. Now, and at that time that we were discussing it, neither of us had Agent Diedrich's testimony right at hand.
Well, I know what Agent Dietrich's conclusion was and what his statement was. What I believe the significant statement in his testimony was that there had to be pressure.
Well, my only question to you, sir, is neither of us had that precise testimony at hand.
No, no.
Okay. Now, I'd like to read you something and ask from Agent Diedrich's testimony on this
Sure.
issue and ask if you agree with it. All right? Sure. It's from the real time, so. And if you want to look along. Question. This is to Mr. Diedrich. And on Mr. Goldman's jeans, you saw areas where it was saturated. Answer, it appeared to be. Now, question. Now, another scientific fact, or would you agree that another scientific fact about these imprints is that they were in blood, but also that the imprint on the envelope, the piece of paper, and the jeans actually are static? That is, they show evidence of little movement. Answer, Well, it's difficult to say with the genes because I think I have already testified that it might be a swiping or moving type motion that may have caused that. But the papers is probably static. I think the papers were sitting and then something landed on it. Do you recall that?
Yes.
Question. So you would agree that in terms of the observation also, that we could agree it's a scientific fact that the bloody imprints were made and impressed with relatively little movement? Answer, yeah, that's reasonable. I don't really know the dynamics, nor could I say with 100% certainty what the dynamics of this were, but it was probably laying down and something landed on that one area. Do you recall him saying that?
Yes.
Question. And you would think that would be the most reasonable interpretation of how the imprint got on the paper and how it got on the envelope. Answer, yeah, that's more logical than having the paper float down and land on something, and I think it's more reasonable. Do you recall Agent Diedrich saying that?
Yes.
All right. Now, do you disagree with that?
No, I totally agree. May I
Okay.
explain?
All right.
No, he said, I totally agree. Next question.
All right. And then there was further discussion, just to read it all. Question. But it would be fair to rule out in terms of your interpretation that the imprint, for example, on the envelope of the piece of paper could have come about with the envelope or piece of paper hitting the jeans and then falling to the ground. Answer, I don't know. I think I said that it seems reasonable that the papers were laying flat and then contact occurred causing the imprint's pattern. That seems to me logical. Excuse me. But there has to be some force, some resistance to that contact, so the paper, if it were not on the ground, would have had to have been against something so that the imprint occurred. It wouldn't be floating. It would either have to be either held or on something else. Question. When you and I were talking before, we were operating on your premise that this could have come from Mr. Goldman's genes, these two imprints. That, didn't you indicate, or aren't you saying that you felt it unlikely that either the piece of paper or the envelope could have gotten these imprints if they had just touched the genes? Answer, yeah, I think I've already testified to that too. Yes. Fair
Yes.
enough?
Yes.
Okay. Now, without repeating the entire discussion, can we agree that on direct examination you told us that you did not believe these parallel line imprints on the envelope and paper were typical of the parallel line imprints one expects to see from shoes?
That's correct.
However, it would be fair to say that there are many parallel line imprints in shoe patterns.
Yes, there are.
And you have a computerized database of shoe patterns at the FBI.
Yes, I do.
And that was the computerized database that you consulted when you were looking for the Bruno Maglis.
That's correct.
And I guess as of Friday, you had not reviewed that database looking for the parallel line imprint on this envelope, yes or no?
No, I would not.
And over the weekend, you have not done that either, have you?
No, I would not.
Now, there were test imprints of the genes that were created in this case.
It's my understanding that Doug Diedrich prepared some when he was out here, and I know there were some prepared prior to his coming, yes.
Right, and one set were done on August 21st at the LAPD lab by LAPD personnel, and some were prepared on August 31st.
I don't know the exact dates, but it was in August, yes.
Right. 2 on August 21st and 5 on August 31st.
Okay.
And, Your Honor, we don't have the, upstairs they have the full set of imprints, but what I have here are Xeroxes of the actual imprints in 2 pieces of paper. They appeared in 1 piece of paper. So for the sake of expediting things, could we mark these 2 documents, defendants next in order, and then we'll later substitute it with the full imprint pad, if that's okay.
1376. And this is going to be test impression from the jeans.
Test impressions from the jeans.
Do you know what date that was taken?
I'm sorry?
Is this the LAPD or the FBI?
These are the ones that were done by the LAPD and sent to the FBI that form the basis for the boards.
All right, these are the 821 impressions.
They're 831 and
821 or 831?
they're all dated on the paper.
821 or 831?
There's one on 830, there's one on 831, another on 830, another on 830, another on 830, and another on 830 in the 2 pages I have.
All right, multiple dates. All right, thank you.
But they're each labeled. Have you seen these test impressions before?
These are of the jeans, yes. They have actually my initials on them because they passed through me.
Okay. Now, Your Honor, may I put these on the yellow?
Yes.
Now, Agent Bodziak, the manner in which these test impressions are created is that the jeans are laid flat on the surface.
I wasn't present when these were prepared.
Have you seen subsequently pictures of how they were done?
No, I have not.
Well, let him show you what he's going to show you first.
Well, I gave them. Let me just establish this while Ms. Clark is looking at the various pictures. Are you aware that pictures were taken of the process by which these test impressions were made at the LAPD laboratory?
Objection, that's misleading.
Only now that you've just told me, no.
Okay. And would it be,
An objection, speculation.
Overruled.
did you have any, withdrawn? Would it have been was it your recommendation that the manner in which these test impressions be made, that the jeans are laid flat, and then this yellow pad, this palm print chemical pad is placed on the jeans, and rolled, and then subsequently a white piece of paper is put on the jeans, and then these impressions are made by the interaction of the chemicals from the yellow pad onto the white piece of paper? Is that how it works?
I wasn't present when they were made. I didn't direct the obtaining of these impressions.
Well, you sent the identicator kit to the LAPD.
Yes, I did.
And you have testified that you've used this yourself for purposes of taking impressions of soles of shoes and I think socks whereby people step on them.
Right, that's correct.
Now, is the method that when you sent this identicator kit to the LAPD, did you direct them that the method of creating the test impression would be to lay the jeans flat and then place the yellow palm print pad on it and roll it and then place the papers on it.
I've never used a roller, so I know I would not have recommended that. Not that there's anything wrong with it, but with shoes and socks, it's easy to wear them and step on the object.
Why wouldn't you have recommended the roller in this case?
Well, it's not that it wouldn't in the case of a fabric. I don't conduct fabric examinations, so I don't get into that kind of a problem. But there would be nothing wrong with using a roller. You're getting a representative sample of the jeans. But I'm more used to taking the object and pressing it on the pad and then onto the paper because I deal with shoes and socks.
You ready?
Well, are you going to use any of these at this point, Mr. Scheck?
Well, I'm going to show him these pictures.
All right, sidebar with Court Board, please. All right, thank you, counsel. Proceed.
I'd like these next two documents to be marked defendants 1337. It's two LAPD reports.
1377.
Objection, no foundation.
1377.
There's no foundation for this time. Seriously.
Just showing to the witness, Your Honor.
Proceed. It's marked 1377.
1377. Thank you.
1377.
Agent Bosiak, I show you two documents marked 1377. Now, in your work as an expert witness, is it your practice generally to rely upon descriptions of procedures used by other laboratory personnel in preparing items that you will inspect for purposes of making comparisons?
Objection, irrelevant.
Overruled.
What's the purpose of showing the documents?
Overruled.
I'm sorry, could you say that again?
Sure. In the course of rendering an expert opinion on the basis of making comparisons of imprints, is it your general practice to rely upon the documents and laboratory procedures of other police personnel or scientific personnel who you direct to do certain work?
With regard to impressions? Are you mean if they take impressions and then send them to us to make an examination?
Yes.
In some cases.
And when you receive both impressions and police reports or scientific memorandum indicating how they were prepared, it's your general practice to rely upon the scientific personnel's records of how they were prepared.
You certainly would read that and take it into consideration, yes.
All right. And in this instance, the two documents I showed you, do they reflect the reports of the LAPD personnel with respect to how they created the test impressions for the genes?
Objection, hearsay, speculation, no foundation.
I'd have to finish reading them.
Please take your time and examine them.
Okay, I've read them.
And based on these documents, as a basis for your expert opinion, would you rely on the fact that...
Counsel, we're missing a few things, aren't we?
Missing these things at this point? Would you regard these reports as reports that would ordinarily be relied upon by an expert such as yourself as a basis for rendering an expert opinion?
Objection, that calls for speculation. There's no foundation. People would ask to take a witness on what guy or principle.
Overruled.
In most cases, if we were sent test impressions, and I can only speak for shoes because I don't do fabric exams, which is what you're asking about. But with regard to shoes, we are many times sent test impressions of shoes, and we may be able to do a comparison, like an elimination type comparison with those. If it was the same design of the shoe impressions in question, of course, we would expect that they would send in the shoes and we would not do any exam at that point, except a preliminary exam, perhaps on class characteristics. And I think that's what's done in this case. I've never seen anyone so thorough as to write a report attached with those impressions as to how they were taken. So I can't reference any other instance.
Well, you saw the boards created with respect to the test impressions of Mr. Goldman's genes.
Yes.
And you looked at those and compared them with the imprints on the envelope and the piece of paper?
You're referring to the boards, meaning the exhibits?
Well, the exhibits that Agent Diedrich prepared, the actual envelope yourself, you yourself made a visual comparison between the test impressions created by the LAPD that were used for the boards and the actual imprints on the envelope.
No. The sequence of events is this. I had the envelope with the impression on it. I had a picture of the triangular piece of paper with an impression on it. I had the jeans which were photographed, which I had previously examined for footwear impressions and determined that there were only two possible ones, and none of those are the parallel lines you're referring to. In looking at the characteristics of the small little fingerprint size or smaller fingerprint size parallel lines on the envelope and the piece of triangular paper, I referred that to Mr. Diedrich because I believed they might be fabric impressions.
Your Honor, I don't think this is responsive. The question I'm asking you, sir, simply is,
Counsel, it was a responsive answer.
I'm asking him if he saw the test impressions. He's telling me
explaining.
everything before that.
He's explaining it. Ask your next question.
Mr. Bodziak,
Ask your next question.
Mr. Bodziak, simply asking you, sir, did you visually examine the test impressions created by the LAPD and used by Mr. Diedrich for his boards to the parallel line imprints on the envelope and the piece of paper? Did you do that?
I did not conduct an examination. They passed through my hands, but I did not conduct an examination.
So you're telling us that you never looked at them?
I looked at them, but it was a fabric examination. Mr. Diedrich does that. I don't.
Well, in the course of your testimony on Friday, did you not express a view that you thought that the imprints on the envelope and the piece of paper were likely to have come from Mr. Goldman's jeans?
I expressed that as a possibility through common sense and what I have seen in the case, yes.
But you're telling us that you expressed that opinion without yourself actually having compared the test impression, looked at them, the test impressions that were created, and then looked at the parallel line imprints on the envelope and the paper?
I'm not an expert in the area of fabric comparisons, and I did not conduct a final comparison, but I did see certain characteristics both in the photograph of the jeans themselves, and in those items which passed through my hands and referred them to Agent Diedrich.
So the answer is yes, you looked at the test impression and compared them to the imprints.
Yes.
Okay.
Not in an examination way, but just a visual.
And was
I saw them.
And was
Yeah.
that visual comparison, sir, part of the basis for the expert opinion that you rendered on Friday?
It's part of many things I saw in this case, which was, of course, the foundation for which I stated my opinion on Friday.
But that was part of your expert opinion.
That's correct.
And in rendering that expert opinion, would you not rely upon the documents created by the Los Angeles Police Department as documents that would be reliable and something that an expert such as yourself would rely upon in
You've asked
forming...
this question already.
Well, all right. Then let me proceed directly. Would you accept the representation in the LAPD?
Wait. Have you seen these reports before?
No, Your Honor.
End of inquiry.
Well,
It's not the basis of his opinion if he hasn't seen it before.
let me ask you this then. Ask you to assume that the test impressions were created by laying the jeans out flat, putting the yellow pad upon it, and rolling the yellow pad with a roller, putting a roller over the yellow pad, and then placing a piece of paper on top of it.
Or will
Are you with me?
I understand, yes.
Now, if that were to occur, would you not expect that the ridges creating the imprint, all right, on the paper, the ridges from the jeans, would be stretched out because the jeans were flat and there was a rolling of them?
Objection, Your Honor, this is beyond the scope of expertise.
want to take him on board, Dyer?
Yes, Your Honor.
Proceed.
Excuse me.
Well, Your Honor,
This is a shoe print expert, not a fabric expert.
he rendered an opinion based on the visual
He
comparison.
said he looked at it and passed it on.
All right, maybe I can shortcut this. Are you telling us that because you're a shoe print expert, not a fabric expert, you would not be able to and express an opinion about whether or not rolling the palm print pad on the jeans would tend to expand the distance between the ridges on the jeans, tend to spread them out?
I don't make test impressions of fabrics except socks, which would be worn with some kind of protection in between. So I couldn't answer that question based on my expertise and experience.
Now, Agent Bodziak, did you ever measure the distance between the ridges on the envelope and compare the distance between the ridges on the envelope to the distance between the ridges on the jeans in the test impressions?
Not with a measuring device, just with a side-by-side look at them in a preliminary sense prior to referring it to Agent Diedrich.
To your knowledge, has Agent Diedrich ever made those measurements?
I have no knowledge of the examination Agent Diedrich performed.
When you do shoe print comparisons, do you perform measurements on the distance between imprints that you see?
No, there's two things we do. We use a divider, which you would apply the points of the divider to one measurement, transfer that divider, which remains at a fixed point, to the other. But more commonly, we use an overlay technique where we would make a test impression of the shoe with a clear material and superimpose that over the question impression. That reduces any possibility of error in measurement. It's a more direct comparison.
Well, the first method that you described is you would take some kind of, what are those devices called? Calipers of some kind?
Well, a caliper is a divider with a measurement scale on it. You only
Right.
need the divider.
Right.
You don't actually need a caliper.
So a caliper would be one of these devices where you would, it has 2 points on it, and you stick it between two things, and there's a little a device that shows you how far the distance is between the 2 points.
Not the ones I use. It just holds that position. You can lock it into that measurement.
There are some that have that measurement on it.
Yes.
And then there are the ones you use don't have a measurement on it, but you basically take the distance on one shoe imprint, and then using the same measure, you go over and look at the other one.
That's correct.
And that's a form, would you not agree, of measurement, even though you don't write down a precise number?
I believe it's more accurate than measurement, yes.
More accurate than?
Yes.
Okay. And so that and the use of overlays to try to show that the imprints are reasonably similar are techniques you use to demonstrate that one shoe imprint corresponds to the other.
In the comparison, it would be if they're similar or different. You can use that technique, yes.
Now, would you not agree, and can we put this up again? With respect to the test imprint here,
1376.
1376, one sees at different points that the so-called inkless fingerprinting chemical, right, when pressed on to the jeans, there was ink, so to speak, that would go between the ridges of the jeans and show up on the imprint.
Objection, beyond the scope, speculation.
You're referring to the filling in between parallel lines and some
Yes.
A's? Yes, I can see that.
Okay. And would you not agree that the media used to do this test impression is not as thick as blood?
That's correct.
And would you agree from your examination of Mr. Goldman's genes that many areas of his genes were saturated with blood?
That's correct.
And I take it that you have never conducted experiments of imprints of fabric in blood.
As I previously stated, I'm not a fabric examiner.
Now, you said on direct examination that imprints made in big globs of blood get darker with time, but most tracks that are blood imprints that are light get lighter with time. Do you recall that testimony?
I don't think it was stated exactly that way.
Well, let me read you this and see if it refreshes your recollection. So most of the tracks are very, very light. The only exception would be if you actually stepped in a pool of blood. With regard to those shoe prints, which I encounter daily and have for my entire time in the FBI laboratory, they become lighter with time. With regard to whole blood or big globs of blood that are very thick, they tend to appear darker with time.
That's correct.
Okay. Now, so you are making a distinction here between imprints made with big globs of blood and imprints in blood that are thinner.
I'm making a distinction between a thick quantity of blood and a very thin, pressed out quantity of blood, and what the differences are that occur over time.
Okay. And you're saying that the ones that are thinner and pressed out will get lighter over time.
The footwear impressions that I incur daily, the typical scenario of what I get in a case is a crime occurs anywhere from 2 to 3 months away, and I have a case right now from 1980. I will get crime scene pictures taken the day of or the day after the murder showing these footwear impressions. I will also, in many cases, get scatter rugs, cut out pieces of carpeting, tile floors or linoleum floors that are rolled up and sent in with the actual impressions. I receive those and examine those on the average months later. In every instance, the thin shoe prints have all but disappeared. The real thick-blooded areas that are now flaking and crusting are darker.
Well, so now you're saying that these are imprints that you're looking at months later.
I believe that's what I said the other day.
All right. Now, I was looking, this is your book.
Yes, it is.
Impression evidence. And I was looking over the weekend, and I was trying to find some passage in your book that discussed this phenomenon. Do you discuss this phenomenon anywhere in that book?
I don't know if there was an appropriate part where I actually said that. I talk about enhancement of blood impressions that are very faint. Obviously, if they were all darker with time, you wouldn't have to enhance them. But I don't know if I actually stated what you're asking specifically that way.
So there's, to your best of your knowledge, there's nothing in your book that corresponds with the testimony that you gave the jury on Friday about faint imprints in blood not getting darker but lighter over time.
Objection, it's irrelevant, beyond the scope.
I don't know if there was a reason why I should state that. I spent a whole chapter talking on enhancement of faint impressions. Wouldn't be a reason to try to give reasons why they may be faint, but just that they are faint.
Well, you have chapters in here about awareness, detection, and treatment of footwear impression evidence.
That's correct.
And you actually have a section in here about impressions in blood.
That's correct.
And you are writing with the purpose of informing crime scene personnel as to what they can expect to encounter when they look at bloody imprints, perhaps from shoes at a crime scene.
I was addressing what they should do to retrieve those impressions and enhance those impressions, and to locate those impressions. To be aware that they could be light, they may miss them, and that those light ones have as much value as darker ones.
Well, you do devote considerable time in this book to identifying impressions made in blood.
Positive identification of footwear impressions.
I mean, in other words, when I mean identify, I mean criminalists going to the scene and actually recognizing the impressions.
The first chapter basically is generally on the detection and awareness and potential of footwear impression evidence, the fact that it occurs in many different ways and for many reasons, both in blood and other materials. Then the next 3 chapters go on how to retrieve it photographically through casting and lifting. Then the 5th chapter is on the chemical enhancement, part of which is in blood.
Okay. Well, we'll review that in just a minute, but just on this one point, so we're very clear with the jury. You were saying then on Friday that when you have globs of blood,
Counsel, this will be the 3rd time we're going through this.
well, I just want to make clear,
No.
let me ask you
Not
this
so.
question. Isn't blood from an imprint blood?
Could you restate that?
Yeah. When you make an imprint in blood, whether it's a glob or a thin imprint, the imprint is made in blood.
Well, you wouldn't have a... You may have misunderstood what I meant by glob. I'm talking about a body at a scene in which a lot of blood has been spilled. There will be pools of blood, and as they go through the changes before they become hard, they can get it to be rather gelatinous, or, in different consistencies, particularly if the body is rolled over on the bleeding is under the body. And in fact, when the remainder of the area where the blood is thinner has dried, if the body is rolled over, the areas under will still, in many instances, be tacky, and that pooling of blood, that thick blood, is what I'm talking about with what I meant when I said globs.
That's what you meant by globs. But
Yes.
what I'm directing your attention, sir, is to your assertion that faint imprints made in blood, that get lighter over time. You recall that?
Oh, absolutely.
Now, those faint imprints made in blood are nonetheless blood.
That's correct.
And blood has certain chemical properties.
Yes, it does.
And when protein breaks down in blood and bacterial degradation occurs, blood turns darker.
If it's in a thick quantity, you will see it turn color and darker. If it's thin, as I've stated, it will fade away due to, I guess, ultraviolet radiation and other things. But that's what I've seen in every case for 20 years.
Right. So you're saying that, but that's, you're talking about getting something months later.
The average case is probably 3 to 6 months from the time of the crime.
So 3 to 6 months is what you're
That's a
generally
rough
saying.
average. We don't keep statistics on that. I haven't averaged every case I worked, but I'm trying to give you a ballpark figure.
And imprints made on June 13th, or June 12th, I should say, and then looked at 13 days later on June 25th, that's not 2 to 3 months.
No, it's going to get lighter, though. I mean, I've gotten cases the same
But
day
is that-
when I was at the
only
crime
asked
scene.
you
Yes.
whether that was 2 to 3
But I
months.
want to be clear.
No. The answer was non-responsive.
That was,
Answer stands.
we agree on the dates, don't we?
Of
Between June 12th and June 25th,
Right. Yes, I do.
13 days.
Right.
Now, is there any serological reason, in terms of the properties of blood that you know of, that would prevent a thin, by your definition, imprint in blood being darker 13 days later than when it was left?
No, to answer your question, I am not a serologist. I can't give you the chemistry of blood. I can only testify to my experience.
Right. And your experiences, we've now clarified, is with faint impressions that you're seeing 2 or 3 months later.
Seeing them everything from the same day to, like I said, I have a case now from 1980. That's quite a distance. And in every case, they only get lighter with time.
Now, latent imprints are imprints that are not visible to the naked eye.
That's correct.
And shoe imprints made in blood can be latent.
That's correct.
And you agree, do you not, that the location of footwear impression evidence, primarily on ground surfaces, makes it sometimes difficult or inconvenient to find, particularly if the impressions are latent or nearly invisible. Specialized lighting and enhancement techniques are often required, along with an aggressive effort to find the impression.
That's correct.
And do you agree that before beginning the crime scene search, careful thought should be given to what occurred at the crime scene, how footwear impression evidence could contribute to the proof of facts, and what areas of the crime scene might contain footwear impression evidence? Then the footwear impression should be looked for aggressively and carefully. What is not looked for will not be found. You agree with that?
Oh, absolutely. I wrote it.
And you agree that lack of success in finding footwear impressions at a crime scene is often due to the investigators not believing that latent footwear impressions will be found and not aggressively looking for them.
As a general statement, yes.
Now, the close-up pictures that you received from the Los Angeles Police Department of the Bundy Walkway area, close-ups now, were directed at the clearly visible bloody imprints that you later identified to be from Bruno Magli's shoes.
That's correct.
Now, do you agree that chemicals used for enhancement are very sensitive to small traces of blood?
Now, objection, Your Honor. This is, of course, ruling on. Yeah,
No, this is enhancement techniques, Your Honor.
objection.
Do you agree?
Yes, I do.
Therefore, in areas where blood impressions are very thin and faint, or where the subject has tracked through blood and left a series of blood impressions, enhancement methods can develop a latent or nearly invisible blood impression into a highly valuable impression. In fact, faint impressions, once enhanced, are normally more valuable and detailed than those containing larger quantities of blood.
In some instances, that is true, yes.
Now, have you ever recommended using as an enhancement technique dusting with a Magna brush and fingerprint pattern?
Are we talking about the surfaces in this case or just in general?
In general.
In general, yes.
Do you know who holds the patent on the Magna brush?
It's actually irrelevant.
Sustain.
Have you cited in your book Dr. Lee's work with the TMB enhancement technique as a very sensitive technique that will reveal faint and otherwise invisible traces of blood that works particularly well on light-colored surfaces where bluish-green color will often
Objection.
offer sufficient contrast?
Objection, hearsay, irrelevant,
Oral.
beyond the scope.
Oral.
I believe that was Nutt, Hazen, and Lee, an article they wrote on that, yes.
And you cited that?
Yes.
Page 158 to
Yes.
59 in your,
Yes.
159 in your book. Now, to your knowledge, did the LAPD make an effort to do enhancements of impressions following the trail of the Bruno Magli when the clearly visible footprints disappeared?
No, they didn't, not to my knowledge.
Objection, Your Honor, that's beyond the scope and considered
Oral.
And do you not recommend in your book or do you not say in your book that very often the blood impressions containing the best detail are those made after excess blood is off the shoe?
In some instances.
Now, to your knowledge, did the LAPD attempt to use enhancement techniques in other areas of the Bundy walkway looking for footwear impression evidence on June 12th?
As I previously stated in my direct testimony, I'm not aware of any.
Thank you. And just so we're clear about what this would look like, just one second, Your Honor. Now, I'd like to show the witness. You, page 158 and 159 of your book, do you not show 3 photographs there that demonstrate how enhancement techniques can be used to bring out impressions made in blood that were either latent or nearly invisible and make very clear patterns?
Yes, I do.
Your Honor, may I show these on the Elmo to the jury?
Objection, this is on the relevant.
Sustain. Wasn't done. Sustain.
Well,
It's irrelevant.
Your Honor, I think it's...
Sustain.
Did you review Dr. Lee's testimony with respect to whether or not... Withdrawn. Do you recall Dr. Lee's testimony that when he went to the Bundy crime scene and was examining for footwear impressions on June 25th, that he had about 20 minutes and he was not allowed to use enhancement techniques?
Objection, that's hearsay, called for speculation.
It's his testimony.
Did you hear the testimony?
I heard it, Your Honor. I just don't remember the exact quote of what he said.
Do you remember that to be the substance of what he said?
I really don't remember exactly what was said about that. I was more looking at the visuals of the footwear impressions.
So that's another part of the 5% of his testimony that you don't recall hearing.
I just can't remember the quote.
I'm asking you about the substance.
Well, if I can't remember the quote, sir,
You
I
can't
can't
remember the
remember the
substance.
substance.
Okay.
Mr. Scheck? 10:30.
Now, I'd like to use a...
Mr. Harris?
Okay.
And Mr. Scheck, which exhibit is this?
I'm sorry? Oh,
Mr.
yes.
Harris, which exhibit
I
is
think
this?
this must be 1337, if I recall. Is that right, Mr. Harris?
Right, 1337.
Now, I've taken out the board 1337 entitled Imprint Evidence at Bundy. You see that, sir?
Yes.
Now, I believe you testified on Friday or Thursday, I can't recall which, that you were confused in watching Dr. Lee's testimony, and you were sure other people were confused whether he was referring to shoe prints when he used the term imprint on many occasions.
That's correct.
And you indicated that you were here to clarify Dr. Lee's testimony so it's not misleading.
Well, I think that the effect of my testimony is to do that to some extent, yes.
Now, do you remember Dr. Lee's testimony on direct examination with respect to the photograph at the far left-hand bottom corner of 1337 that was taken on June 13th by the Los Angeles Police Department?
Yes, I do.
And Vegas with David on.
Overruled.
Council's proposing to read, may I see what he proposed?
Yes.
Yes.
42772.
Objection under 356. 352 is misleading. I'd ask that you please.
Whose testimony is this?
This is Dr. Lee's.
Ask the question.
Now, with respect to that picture, the bottom left-hand corner of 1337,
What's the labeling on the bottom of it?
it's indicating walkway 612-1394. Do you recall seeing, because you saw Dr. Lee's testimony in videotape, correct?
Yes.
Do you recall seeing or hearing Dr. Lee testify on direct examination to the following? And I'm starting, Your Honor, at page 42772 of this transcript. Question. And incidentally, Dr. Lee, with respect to the parallel line imprint pattern that you identified for us on this June 12th, June 13th walkway photograph, in theory, is it possible that the imprint pattern could arise from an imperfection in the tile? Answer, it could be, because I only look at a picture. I myself did not have an opportunity to go there, identify the tile. It could be anything. What I don't want to mislead people, and ladies and gentlemen, say that is a shoe print. By no means, I did not say that is a shoe print, just a partial imprint with some parallel lines.
Question.
Do you recall him saying that?
Yes, I do.
That was on direct examination.
That's correct.
Do you regard that as in any way misleading to this jury?
My statement about misleading was in context to his whole testimony.
I'm asking
I wasn't-
about this.
In this one, I think he clarified it that if he had inferred before by saying it was an imprint, that he meant it was a shoe print, he was saying later on that it wasn't a shoe print,
But
with
let's-
regard to this particular one.
Direct examination, the section I just read you with respect to that picture, to recall that testimony, my question to you very simply is, do you regard that answer on direct examination as an effort to confuse the mislead this jury in any way?
Objection, Your Honor, under 356 and 352 is misleading.
Overruled. Restate the question. The way the question is stated, it's argumentative.
Okay. With respect to the section I just read you from Dr. Lee's direct examination with respect to that picture, do you believe that in this question and answer, Dr. Lee was misleading or confusing anyone?
Not with regard to that particular statement, no.
Now, do you recall that when this issue then arose on cross-examination, what Dr. Lee said about it?
No, I don't have this committed to memory. I saw most of this, but I don't have his quotes committed to memory, sir.
Well, I'm not asking you about quotes, I'm asking you about substance. Do you recall the substance of what he said on this?
It's my opinion from what I saw that he admitted that these could be trowel marks in the sidewalk or imperfections in the sidewalk. But I don't remember his quote exactly.
All right. Second, I'm sorry, Ernest. To save some time, do you recall that Mr. Goldberg showed Dr. Lee an enlarged picture of that tile?
Objection, Your Honor. Objection, Ms. Small.
Sustain. Phrase the question.
Do you recall that Mr. Goldberg showed Dr. Lee a picture which Dr. Lee remarked was a better picture than one that had been available to him?
I don't remember that part exactly. Again, maybe because it wasn't part I saw, or I just don't recollect that far back.
And do you recall that when Dr. Lee was shown that photograph, he immediately told Mr. Goldberg, yes, this is a better picture than I had, and looking at that tile, I now agree the most reasonable interpretation is that those parallel line imprints came from the etchings in the tile.
No objection, that misstates the testimony.
Sustained.
I'll get back to this after the break. Now, with respect to this is 1337B, and that is, you agree, a blow-up of the middle photograph entitled Walkway 62594 on 1337.
Yes.
Now, Dr. Lee identified a parallel line pattern that he entitled PLP,
Yes.
and he indicated that by way of tests and observations that he made on June 15th, that this was an imprint in blood.
I don't believe I recall him calling it conclusively in blood.
But consistent with an imprint in blood based on his tests and observations at the scene.
I don't recall that specific part of it.
Sustained.
Let me ask you this question, very simply, yes or no. Do you agree that this parallel line imprint pattern identified by Dr. Lee is consistent with having come from footwear?
I don't believe, as I previously stated, that you can look at that area and say any of that has positively come from footwear. It could, but it wasn't there on June 13th.
So, move to strike the last part of this answer is non-responsive.
Stricken is non-responsive. Last part.
Simple question, yes or no?
You can't tell from that partial of an impression, and I stated that on direct.
But did you not state on direct that, in your opinion, this parallel line imprint pattern could come from footwear?
It could have come from footwear.
And isn't it your understanding that that's what Dr. Lee said as well?
As I recall, he referred to that area as a parallel line imprint, and he was asked many times about it on both sides and said it could have come from a shoe. I don't believe he conclusively said that it came from a shoe.
Right. He said just what you just said.
Right.
Now, with respect to this wiggly line that one sees above the Bruno Magli, see that?
The wavy line,
The wavy line.
yes.
Well, did not on direct examination Dr. Lee simply refer to that as wiggly line pattern?
That sounds correct, yes.
And he did not circle that.
Not there, no.
And Mr. Goldberg asked him some extensive questions about that on cross-examination. Do you recall that?
That calls for a conclusion as to what's extensive.
Did he ask Dr. Lee some questions about this wavy line pattern on cross-examination?
I don't remember how many he asked him, but he questioned him about that, yes.
Right. And when he was questioned about it on cross-examination, did Dr. Lee indicate that he had performed tests on the parallel line pattern, but could not recall any tests being performed on the wavy lines?
No objection, that misstates the testimony about it.
Oh,
Well, again, I'm not able to memorize all of that testimony. I saw parts of it, parts on the East Coast were cut out, and a lot of it I don't recollect because it's been some time. So I'm not going to get into the quote game. I'm sorry, I just can't remember that.
You, on direct examination, indicated that this wiggly line pattern was an imperfection in the sidewalk.
It's a shoe print in concrete.
Shoe
in the
print in
sidewalk,
concrete.
Yes.
All right. And this was passed out to the jury, and this was all pointed out to them, right? There's a
That's-
shoe print in concrete.
That's correct.
And when you did that, or when that was done, were you in any way trying to represent to the jury that Dr. Lee had maintained that this wavy line pattern was an imprint made in blood?
Are you asking me my intent of explaining all of these, or just this one specifically?
When you did that, were you aware that Dr. Lee had never represented to this jury that this wavy line pattern was an imprint made in blood?
I don't recall him saying anything that I saw. I don't recall him saying it was made in blood, no.
And in fact, to the best of your recollection, his testimony was directed just to the parallel line pattern as an imprint made in blood that could be consistent with the shoe, just as he drew it in this picture.
You're asking me about quotes about him talking about things conclusively made in blood. I don't remember that part of it. I remember the parallel lines as possibly being a shoe print. I don't remember the blood portion.
And the parallel lines possibly coming from a shoe print that he drew, Dr. Lee said, with respect to that, exactly what you said here today.
Which is, it's parallel lines that could have been made by a shoe.
Right.
With the exception that I'm saying,
No. Is that
Okay.
Is that right?
Objection, Your Honor. That's-
No.
You can finish the answer, counsel.
Well, if he's going to start saying
You
about
can finish the answer. That's the way you asked the question.
no,
Have you finished your answer?
no, sir.
Finish your answer.
Except that I also determined that that impression was not present on the June 13th photographs, which
Right.
were very detailed photographs.
right? And Dr. Lee simply said that he observed this on June 25th,
That's correct.
and well, I think that's enough. It's 10:30.
All right. All right, ladies and gentlemen, we're going to take our mid-morning recess at this time. Remember, all my admonitions to you will stand in recess for 15.
Please declare the court.
Stand, please. All right, Mr. Scheck, you may resume your cross-examination.
And hopefully conclude, Your Honor.
Amen.
Now, Agent Bodziak, the picture to the far right on 1337 and the blow-up, which is marked 1337A, you recall this one.
Yes, I do.
Yeah, Mr. Scheck, could you just give me the labeling on the 1337?
It's called Walkway 62594, but it's the one on the lower right-hand corner, and 1337B is the blow-up that's labeled with the circle PLPSP, standing for shoe print.
Yes.
All right. Now, you recall Dr. Lee's testimony with respect to this particular imprint pattern.
Yes.
And you recall that he testified that in his opinion, this parallel line imprint pattern was a shoe print.
Yes.
Do you agree that this is a shoe print?
It's more than likely a shoe print. I mean, it looks very much like a shoe print, but it's, again, partial.
Well, in your opinion, then, it's more than likely a shoe print.
Yes, yes.
So you would agree in that respect with Dr. Lee that this is a parallel line imprint that's more than likely a shoe print?
Yes.
Now, is this one of the kinds of imprint patterns that you believe would get lighter over time as opposed to darker?
What is it composed of?
Well, Dr. Lee testified that based on his tests and observations at the
Objection,
scene.
Your Honor. Objection.
What's the objection?
Yes, Your Honor.
Oh, if they're going to imply it's not,
Objection.
we approach sidebar.
Sustained. The objection is sustained. Rephrase the question.
All right. Dr. Lee testified based on the work he did at the crime scene and his observations that he believed that that parallel line imprint was made in blood. Where that?
Same objection, what you did.
Overruled.
Yes.
Now, if we assume that that is indeed made in blood, would you believe that that imprint pattern is the kind that would get lighter over time, and here I'm talking about a period of 13 days, would it get lighter over 13 days or darker?
If this particular impression was an impression made on June 13th in blood, it would only get lighter.
And do you have any, and it's your testimony that this would get lighter?
Absolutely.
And you're saying that these, assuming that there was an imprint pattern made on June 12th in blood with this configuration,
Yes.
is it your testimony that the lines in blood would not break down in terms of the proteins and the bacterial degradation, and those lines get darker?
Well, the first part I would agree with. They would degrade, as any blood would, when exposed to the weathering and time, particularly over that time period. But based on my experience in casework, as well as blood impressions, which I prepare for classes and then maybe don't use for 9 months later, purposely to make them light, for chemical enhancement in those classes, they always turn lighter, without
Well,
exception.
You just mentioned 9 months.
They gradually get lighter with time, sir. Doesn't matter what the time frame is. As more time goes by, they will get lighter.
And can you, now we're talking now just to 13 days. You realize that?
Yes.
And can you tell us what scientific, chemical, serological properties is the basis for your opinion that an imprint that size made in blood would get lighter within 13 days as opposed to darker?
So say we've already asked this question.
Well, this is on a different imprint of a different size.
But we asked the same question.
Okay.
We've already been through the lighter and darker.
So your answer would be the same as the one we went through before, that you're not a serologist?
May I answer that?
Yes.
Yes, my answer would be the same. It's from experience.
All right. But you're not a serologist?
No.
To the base, you're aware of the fact that Dr. Lee is regarded as one of the foremost serologists.
Overruled.
Again, I've stated my knowledge of his qualifications. I don't work with Dr. Lee, and I don't have very extensive knowledge of exactly what his strong points are in terms of experience.
Well, you indicated, I think first you said you hadn't read any of his books, and then you indicated
We've
that you...
gone through this. We went through this last week.
Well, any of the books that you skimmed of Dr. Lee?
Counsel, move on.
Now, you do not have a close-up, direct picture of this tile from June 13th.
Not that part of it, no.
And basically, what you told this jury before is that you were looking at some overall shots, and looking at those overall shots, in your opinion, you could not see this imprint.
The large photographs, which I had labeled, starting with E on 1 and going through, I think, L, M, and O, which were general scene shots, but you could see the tiles fairly well. I could not see that impression on the 10th row of tiles, which is where that's from.
Now, these...
Well, excuse me, I'm sorry, counsel. When we say that, we're talking about 1337A, is that correct?
Yes.
All right.
Now, these pictures that were labeled H, that you used on your direct examination, those blown up pictures of the scene, you recall those?
Yes, the ones you just showed me at break.
Yes. I think that... Now,
All right, Mr. Harris, which exhibit is this?
this is
598.
598. And we were making reference before to the pictures labeled A, B, C, and then we had some labeling problems, J and K. You recall those?
Yes.
All right. Now, those pictures were created by you sometime in August.
These particular prints were created by me in August, yes.
All right. And that was in anticipation of Dr. Lee's testimony.
I was requested to print those, yes, for that reason.
And you have never received contact sheets of the pictures taken from the crime scene from the Los Angeles Police Department.
No.
And are you aware that the defense has repeatedly asked for contact sheets in this case?
Sustain.
Oh,
Sustain.
may I approach?
No. Proceed.
You were sent in August the negatives. Were you not?
Yes, I was.
And you then, from these negatives, were able to prepare enlarged contact sheets.
That's correct.
And from those contact sheets, you could then select out photos and do enlargements.
Well, no, from the original negatives, not
From-
the contact sheets.
The contact sheets directed your attention to the picture. You were then
Right.
able to select it and do
It
enlargements.
saves time, rather than enlarge everything to that size, which would be very costly and time-consuming.
And would you not agree that these pictures that you created in August were of a better quality than the ones that had previously been provided to you by the Los Angeles Police Department?
Which ones are you referring to?
A, B, C, J, K.
Oral.
I had seen smaller pictures of those. I had not requested larger pictures at that time because my examination was about the close-up photographs. But I did have an opportunity to look at the pictures they had available of those other frames.
And you also prepared a picture from the original negative of the socks that were found in Mr. Simpson's bedroom?
I don't recall enlarging a picture of the socks in his bedroom, no, sir.
To your knowledge, during this period, did someone else do that?
They may have, and I don't recall that.
Now, you went out to the crime scene and you took, recently, and you took a series of black and white photographs of what you found to be imprints in the concrete of these tiles,
That's correct.
some of which were footwear imprints.
That's correct.
Now, with respect to, we can take that one down for a moment. Thank you. And with respect to 1337B, the three parallel line imprints, and 1337A, okay, have these in mind?
Yes.
You are not telling the jury that any of those imprints in concrete that you took pictures of recently formed these parallel line imprints in 1337A and 1337B.
No, not just the wavy line and the one in your right hand, whichever that is.
Just the wavy line.
Yes.
Okay. So as far as 1337A, those imprints labeled by Dr. Lee PLP, SP, and 1337B, the one labeled PLP, those were not made from the indentations in the concrete.
That's correct.
And from the indentations in the concrete, you were asked, withdrawn, you were asked on direct examination whether or not those indentations you found and photographed in the concrete could have caused the imperfections and the unevenness in color of the various tiles that one sees in the overall pictures that you recently blew up?
That certainly could be a part of it, but by no means is it all of it.
And did you not tell us that the dark splotchy areas that you saw in the overall pictures and various imperfections, that no one could exclude the possibility that there are other footwear impressions there from just looking at the overall shots?
Are we talking about on June 13th in blood?
We're talking about the overall. You recall that there was one point in Dr. Lee's testimony when he saw these new pictures that you created, that he testified that he saw impressions, dark impressions in the tiles that could be imprints.
I recall strongly one area which I believe at the end of his testimony on recross by Mr. Goldberg, that he just all of a sudden made a general statement pointing to those photographs which were just up here, those enlarged ones that I had made, that there were imprints everywhere.
Well,
I think he might have even called them shoe prints. I don't recall the exact quote, but I know he certainly referred to them as imprints, and the implication were that the walkway, there was many things on the walkway, and he made a really general statement about you could see things everywhere.
well,
So you'd have to get the exact quote out. I can't remember it.
Well,
but I was concerned about that statement.
well, if you're concerned about that statement, would it behoove you to be very specific about it, do you think?
I'm being as specific as I can without being inside of Dr. Lee's mind.
Well, in anywhere did he say that when he looked down that walkway that he could see a shoe print?
There was an open inference. I don't know what he meant.
I only asked, did he say that?
And I'm answering you, I don't know what he meant. He said imprints or shoe prints. There were many of them on that walkway, and he pointed to those photographs in answer to Mr. Goldberg.
So you think that he said that one of the dark splotchy areas was a shoe print?
I don't know what in his mind he was specifically pointing to. He referred to those general photographs.
I'm only asking you about what he said.
Objection, it's argumentative now.
Sustained.
Now, in your testimony here, did you not state that in the overall shot, looking at the unevenness color and various stains and weathering of the concrete style since the walkway was put there, that you can see various lighter or darker areas of imperfections, and it's impossible to tell what they are?
Yes, I'd be happy to show those if we could put that chart back up.
No, but is that what you said?
Yes, it is.
And did you also say that in a very loose sense, if I were asked, or anyone, including Dr. Lee, to look at this, and you see these various dark splotchy areas and imperfections, that you cannot exclude the possibility that there are other footwear impressions, of course, but you can't say that there are footwear impressions there either?
That's a whole lot different than what he stated in his testimony.
That's what you think?
Can I exclude the possibility
I'm
that...
only asking about what you said.
I'm trying to explain that. I can't...
Is that what you said?
Objection, Your Honor.
Now, the question is that what you said?
Would you read it back again?
Sure. So in a very loose sense, you could look at it if you were asked, if I were asked, or anyone, including Dr. Lee, to look at this and say, do you see these various dark splotchy areas and various imperfections? Can you exclude the possibility that there are other footwear impressions? Of course you couldn't. But these are, from my inspection of the scene in these photographs, there's nothing that you could look at, in my opinion, that looks like a shoe impression other than the ones that I have previously testified to.
In a very loose sense, yes. That's exactly what I said.
Now, I understand it's your position that the parallel line imprints reflected on 1337 and identified by Dr. Lee, in your opinion, based on your previous testimony, you don't believe could have been present on June 12th.
That's correct.
However, based on the previous discussion we had this morning, you would agree that, as far as you know, people from the Los Angeles Police Department did not use enhancement techniques on other areas of that walkway on June 12th?
Objection has been answered, speculation.
Oral.
Am I aware if they used enhancement techniques? No.
Okay. Now, with respect, however, to the imprints on the envelope, the piece of paper, and Mr. Goldman's jeans, would you agree, based on the photographic evidence you've seen, that those were present on June 12th and June 13th?
What was present? The parallel.
The parallel line imprints on the envelope, the piece of paper, and the imprints on Mr. Goldman's jeans.
In contrast to the exhibit you just showed me on tile 10?
I'm asking you a
the
very
one-
simple question, and perhaps,
Sustain.
let me just ask you this.
It's a compound question.
All right, I'll take it one by one. Would you agree that the parallel line imprint impressions on the envelope from the photographic evidence you've seen were there on June 12th?
Yes.
Would you agree that the parallel line imprint impressions on the piece of paper were there June 12th?
Yes.
Would you agree that the imprints on Mr. Goldman's jeans identified by Dr. Lee were there on June 12th?
12th or 13th, I believe is the correct date, yes.
As part of the 95% of Dr. Lee's testimony that you recall hearing and seeing, do you recall what he said about the so-called accordion effect that made imprints on Mr. Goldman's jeans?
With regard to,
Objection is beyond scope.
Sustain.
Well, you recall Dr. Lee's testimony. Maybe we could put up a board. If I may. I request that we actually, Mr. Harris, if we could pull that one out and place it in front of the podium. So. This is 1339, Your Honor. Imprint evidence in Bundy, imprint evidence on Goldman's blue jeans. Do you recall Dr. Lee's testimony with respect to this board?
yes, I do.
Do you recall him testifying with respect to certain imprints on Mr. Goldman's jeans that he detected something that he characterized as an accordion effect?
Same objection beyond scope.
Sustain.
Well, did you testify on direct examination with respect to imprints on these jeans?
Objection has to be on the scope as well.
Oral.
Yes, I did.
And would it be important in your evaluation of imprint patterns on the jeans to consider all of Dr. Lee's testimony with respect to how various imprints were formed on the jeans?
Objection is beyond the scope.
Oral.
Goes to agent.
Yes.
And you have no recollection of what Dr. Lee said with respect to an accordion effect?
Not specifically, no. Are you referring to the accordion of a fabric or a shoe? I don't recall, I don't believe what he said.
Does it refresh your recollection that Dr. Lee pointed out certain imprint patterns on the jeans that he characterized as an accordion effect that occurs when the jeans are folded and bunched together?
Objection irrelevant.
Does that refresh your recollection?
Objection.
Oral.
I'm familiar with that phenomena.
You're familiar with that phenomenon?
Yes.
But you don't recall Dr. Lee's testimony with respect to identifying various imprints on the jeans?
In general, I just can't remember his exact quote.
Okay. Now, we've discussed before, and without going into specifics of it, it's your understanding that, withdrawn. Would you agree that the pictures taken of the blue jeans here are when the blue jeans are flat and they are two-dimensional representations.
Yes.
And would you agree that nobody except perhaps a very peculiar, thin individual would, when wearing jeans, have those jeans flat?
That's correct.
That it's a very important factor in considering how imprints were made on these jeans to recognize that there had to be a leg inside the jeans that would affect imprints made upon it.
That's correct.
And as I recall your direct testimony, you recognized the significance of this when you were talking about your arm and slapping your arm to indicate how imprints might be made on your arm.
I believe I had a heel over my arm, and I was showing how hard it would be because of the cloth conforming to the shoe so readily with hardly any pressure to make an imprint of just the interior of the heel over and over with no perimeter of the shoe showing.
So you would agree that the fact that the jeans are on the leg and the receiving surface is three-dimensional would have an effect on how imprints are made on the jeans by another object that comes into contact with it.
Can have a minor bearing on it, yes.
Minor?
Yes, minor.
Well, if the jeans are folded and bunched and there is contact from a flat surface with ridges and that surface has blood on it, could that not affect folds in the bunches, the kind of imprint one sees on the jean?
Objection, improper, hypothetical, irrelevant.
I can only speak with regard to the shoes, and shoes, if the material is bunched, like you're suggesting, and the shoe comes down on top of it and compresses on it with pressure, leaving a shoe print on it in blood when it's bunched, then when it's flattened out, it will separate, and those lines, there'll be evidence of that, evidence that you can recognize as a person that's experienced that, made test impressions that way, and recognizes what you're looking at.
Well, do you recall Dr. Lee testifying with respect to how these imprints were made on the jeans, that he considered the fact that it was three-dimensional and the jeans would be folded and bunched was a significant factor in evaluating these imprints?
Yes, but I don't understand how he could have known exactly what the scenario was since he wasn't there. You could have that scenario and many others, and you have many areas on the jeans, and they would not be the same.
Do you recall him testifying to any particular scenario as opposed to simply testifying that when a leg is inside the jeans and the jeans become folded and bunched, that's going to affect the way imprints look?
Which type of imprint? Again, are we talking of shoe prints or fabric imprints?
Well, Dr. Lee testified about imprints made in blood, whether from shoes or other objects, didn't he?
There's a distinction between them, though. That's the whole point, is that shoe prints are not like fabric impressions, and of the dynamics of what you're hypothesizing here is different for shoes as it is for fabric, because one's a soft material and the other is a very rigid material.
Well, let me ask you this. As I understand the way you have been testifying, you're telling us that you're not an expert in the way imprints are made by fabrics.
That's correct.
You're only an expert, you say, on the way imprints are made by shoes.
That's correct.
Well, in your last answer, you were just telling us about what imprints one could expect from fabrics, as opposed to what imprints could be expected from shoes.
I have made fabric impressions, and it's mostly common sense.
So in other words, you're saying that you don't need any particular expertise about how imprints are made by fabrics. You can do it from common sense.
What I'm saying is you don't need any particular expertise to know that the scenario you're giving is one of many, many, many that could have occurred, and that you would see evidence of that, and that they would not, you have impressions on many different areas of the jeans which were made at different points. You're suggesting they were all made exactly alike with this compressed fabric. It simply doesn't happen that way, Mr. Scheck.
Did I say that all of them were made exactly alike with some compressed fabric now? Did I say that?
That was the inference I understood, yeah.
I understand that's the inference. I'm only asking you, is that what I said?
Not specifically, no.
And isn't it important, Agent Bodziak, to carefully review what another expert says if you're going to come into court and criticize exactly what that expert says?
Sustain.
Do you think it would help to read a transcript?
Excuse me, counsel.
Argument.
Counsel.
Now, you have stated, and I'd ask you to come down and look with respect to imprint number 2 over here. Do you recall on direct examination that your attention was directed to the area of the parallel line imprint on imprint number 2 on board 1339?
Yes.
And this is, in fact, I think, where you had a discussion about your arm.
Yes.
And your direction was drawn to what I'm indicating here within the larger red line, a curved imprint.
That's correct.
Now, you have indicated that you believe that that is consistent, in your opinion, with an elbow from fabric as opposed to a heel from a shoe.
That's not what I said, Mr. Shep.
Okay.
I had a discussion with Mr. Diedrich. We suggested, could that possibly be an elbow? And that was something for him to pursue, not for me to base on my experience.
Okay. So you're not going to venture an opinion about whether it could come from an elbow.
Now, my opinion is that it's not a shoe impression.
Right. And you don't want to say anything about an elbow because you don't feel qualified to state that?
That's correct.
Okay. Now, did you not say that looking within these impressions, and I'm now directing your attention to imprint number 2, the lines that are parallel do not always run parallel to one another?
That's correct.
And could you tell us which ones in particular you're pointing to?
Sure, may I get the pointer? Many lines in this area, and there's 2 right here, which are a little bit offset of what appears might be a continuation, but they're actually 2 that go in this direction, and then 2 that are, well, these 2 on this side are about like that, and these are just slightly turned. These down here are angled up a little bit more in contrast to those. Maybe I could get the other pointer. If I put this over one of these lines and this one over this line, you can see that they're not perfectly parallel.
Okay, just hold it right there for a second, if you may. Okay, just so we're very clear on what you're saying, all right, is that you're referring to, within that heel impression, you see 2 parallel lines.
I don't see a heel impression.
Objection.
Withdrawn. Let me state it differently. Within this curved impression that you would agree is about 3 inches,
There's no scale on this photograph.
when you did a blow-up of
Be
this,
approximately 3.
approximately 3 inches. In the top pointer, you're indicating that there are 2 parallel lines that are in the direction you've indicated here. Is that right?
Yes.
And now you're pointing to 3 other parallel lines below and to the right at the bottom of the picture, correct?
Well, there's more than 3. It's hard to count because but you can see, again, we're running with the fabric, and you're getting blood on a garment that's kind of on its own, just gathering up within that weave. Now, this is right along the parallel lines of the fabric, and so a lot of these lines, you can't look at them and tell whether they just happened to soak that way or whether they were actually from a contact of something. But there's more than 3 down here if you're going to count everything
Okay.
that looks like a parallel.
There's a series below to the right, and then there's the 2 that you indicated that are directly touching the curved line?
Well, there's two here, which appear to be different from two more. This I wouldn't count as really anything because it's all run together. And then there's several down here, which again, they kind of deteriorate into just being blood, which is in the weave of the fabric. So it's very unreliable to say what all of these are.
Well, when you in direct examination said, looking within these impressions, the lines that are parallel do not always run parallel to one another, you were referring to the two sets of lines you've just indicated.
Well, I was referring to the most obvious, the ones up here, the 2 and 2, and the ones down here. You've got some that go outside of this perimeter as well.
I'm only asking to the ones you referred to on direct examination.
Yes.
And the part of the testimony I just quoted, those are the ones you've just indicated to the jury.
Well, I don't think I pointed everyone out, but all of these lines have
Right.
inconsistencies in the angulation of it.
And it's your testimony that the bunching or folding of the genes could not have created the difference in the way those lines are pointed.
I can answer that question, but again, I want to premise it with I'm not a fabric examiner, but I have.
Objection beyond the scope of expertise.
It would be more than likely that the inconsistencies of the direction of these lines would be of the inconsistency of Ron Goldman's shirt than it would be of jeans, which would be more like taut over the leg of him, be tighter.
Now, so the answer to my question is no, it couldn't be from the folding of the jeans. That's what you're saying.
I wouldn't begin to tell you exactly what happened at this crime scene. That's part of the whole point, is that you can look at physical evidence, and sometimes you can determine things, and sometimes you're limited. And I don't think that you can say every one of these lines that runs along the weave of the jeans is a parallel line caused in an imprint fashion, but the ones that you can see are not from a shoe.
Have you not seen parallel line imprints on the jeans that are against the grain of the fabric?
Yes.
And do you recall Dr. Lee's testimony that he believed that the parallel line imprints that ran with, some of them that ran with and some of them that ran against the grain, were made by a flat, thin surface coming into contact with the jeans? You recall him saying that?
I don't recall him saying precisely that.
Now, you're saying that you don't have expertise in the area of fabric impressions.
In terms of comparison, yes.
But you do concede, I take it, that there are a series of parallel line imprints on the jeans, some of them running with the grain and some of them running against the grain.
Yes, there are.
And if the hypothesis that you just put forward, that these imprints were caused by Mr. Goldman's shirt coming into contact with the jeans, would you not agree that that would require his arm or the shirt coming into contact in a series of imprints with the jeans to cause those lines?
Well, there's a series of
Objection,
different.
this is beyond the scope of his expertise.
Sustain.
Do you believe, Agent Bodziak, you said, I believe, that you do not regard yourself as an expert in blood stain interpretation.
Objection
correct.
asked and answered.
And blood stain interpretation at crime scenes would include an evaluation of imprints on garments or fabrics such as blue
Objection,
jeans.
speculation, irrelevant.
My interpretation of blood stain analysis is blood pattern or blood spatter. That it would be limited to the passing of the blood through the air and landing on a surface and the physics of what happened to that blood. In other words, you would look at a drop of blood, and if it was totally circular, you could determine it was approximately 90 degrees to the surface, and if it was at an angle, the elliptical nature of it would enable you to measure through the science of physics the approximate angle, and that you could use this in part to reconstruct, but more importantly, to corroborate or discorroborate statements that might be made by witnesses. As far as when it gets into shoe impressions or fabric impressions of blood, I don't believe that's within the area of blood spatter analysis.
Well, do you think that it's within the scope of bloodstain interpretation at crime scenes that analysts will investigate how various different kinds of imprints are made by objects on different receiving surfaces?
Objection asked and answered.
Sustained. Let me see counsel without the court reporter, please.
Some of it.
Do you feel qualified to comment on any of that?
No, I don't.
Objection is to be on the scope.
Just finishing up and trying to get through this. Now, you heard Dr. Lee's testimony with respect to Ron Goldman's shoes. There was a board that contained Ron Goldman's shoes, keys, a pager, buttons missing, a beeper, and disturbance of soil, all that were directed towards his testimony concerning struggle. You recall that?
This objection to be on the scope.
Oh,
Yes, I do.
Any of that testimony that you feel that you are qualified to comment on?
Objection irrelevant.
sustained. I
Well,
want to narrow it down to footprint.
I'm trying to see what he... Did you examine Ron Goldman's shoes?
Yes, I did.
Did you see a cut on the toe of one of Ron Goldman's shoes?
I examined the shoes for the sole pattern and the foxing strip around the side of it, not anything else. So I didn't see any other features on the shoes.
So in other words, you're telling us you did not see that area that Dr. Lee identified as a fresh cut that would have come from a sharp instrument when the shoe was in the air.
Objection, then the state.
Sustained.
Did you see Dr. Lee's testimony with regard to the cut which he characterized as fresh from a sharp instrument?
On the shoe?
Yeah.
Yes, that's not what I examined.
And you never saw that on the shoe?
I never examined the shoe, that part of the shoe, for that type of evidence.
To your knowledge, did anyone?
I would have no idea. Who examined the shoe beside myself and for what reasons?
Now, in this part of Dr. Lee's testimony, there was reference to soil being disturbed in the closed-in area. You recall that?
Again, my interest in his testimony was concentrated on the shoes. I saw a little bit of the others. I don't remember that discussion.
Well, would not impressions made in soil be relevant in terms of your expertise with respect to footwear?
If he stated shoe impressions, that's a lot different than disturbance of soil.
Well, do you know what he said?
To my knowledge, he did not testify to anything about shoe impressions in soil.
Can shoe impressions be taken from soil?
Can they be made in soil?
Yeah.
If the soil conditions are right, yes.
Now, do you recall Dr. Lee's testimony about the envelope in different positions?
I think that's what we discussed the other day, yes.
All right. You saw that.
Part of it, yes.
Did you see his testimony about the, with respect to the envelope again, about the missing lens from the glass and blood material on the eyeglass frame?
Objection, this is beyond the scope of the relevant.
Sustain.
Did you see Dr. Lee's testimony with respect to bloodstains found in the foyer of the Rockingham home and his examination of the carpet?
Sustain.
Did you see Dr. Lee's testimony with respect to wet transfers on the sock?
Objection, Your Honor, beyond the scope.
Well, is the sock, is socks an area of your expertise?
With regard to what examination?
Blood?
Sustain. This goes way beyond the scope, counsel.
Well, are you confident that you actually saw 95% of Dr. Lee's testimony?
With regard to the
Objection, asked and answered.
with regard to the shoe impression evidence, yes.
Oh, so if I understand your testimony now, what you're saying is that you saw 95% of Dr. Lee's testimony with respect to shoe impressions, but not necessarily with respect to all of what he testified to.
On the East Coast, the coverage of his testimony was limited to part of his testimony. There was time when they cut it off, and all during the testimony, they would go to breaks and commercials about every 10 minutes, which would mean any time there would be a segment of that, I wouldn't see it. I had no way of seeing it. So that's why I've sometimes remember things and sometimes don't, and I have no control over that.
I hate to make this my last question. Do you have Court TV?
No.
No further questions.
Ms. Clark.
Very briefly, thank you. Good morning, ladies and gentlemen. Sir, you indicated at one point that when you look at a shoe print, you don't consider anything else. Can you explain that answer? I believe it was an answer you gave to Mr. Scheck on cross-examination when we broke on Friday.
Yeah, I think that was with regard to the envelope in specific, but in general, when we're looking at a shoe impression, very often there is other excess of blood which interferes or obscures that, or there may be other things which interfere with that impression. If it's in soil, it may be leaves that have fallen in, or sticks or rocks that were in the bottom that prevent reproduction of that shoe detail at that point. And of course, no one can examine things that are obscured or interfered with. So the examination would be limited to the part, in the case of the envelope, that was the parallel line pattern, and any other interferences or secondary or primary blood splatter, stain, or absorption on the envelope would be irrelevant. I would only examine what I could, the part of the pattern that I could see.
Right. So you base your opinion on what you can see, not what you can't see.
Of course.
Now, you indicated that you did not look in your database, in your computer database, for the parallel line imprints that were found on the jeans, the envelope, the paper, correct?
That's correct.
And why is that?
The parallel line imprint, in my opinion, is not a shoe impression.
And if it's not a shoe impression, then will it be found in the database?
Well, there are a lot of shoes with parallel line imprints. and I'm sure some of them would become very close to spacing on those genes, but it's the manner in which the imprint is made on the gene and the absence of characteristics that I, based on my experience, would expect to see in that many impressions. And because I don't believe it's a shoe print, I wouldn't search for something that I didn't believe existed.
And did Mr. Scheck show you imprints made by a shoe that did have parallel lines this morning?
Yes, he did.
And did he ask you for your opinion concerning whether or not those parallel lines bore any resemblance to the ones on the jeans, the paper, and the envelope?
It was limited to the ones on the envelope.
He asked you for your opinion, sir?
Yes, ma'am.
And what opinion did you give him?
I told him they were totally different. Upon looking at that, it's impressive because they're very, very fine parallel lines on the shoe print he showed me. When comparing it side by side, those on the envelope, they're still twice as big, which shows that it would be very, well, in my opinion, impossible to manufacture a mold that would implant that minute a design on a shoe.
Okay. So the shoe impression with parallel lines that he showed you, you indicated to him, were not at all similar to the parallel lines on the envelope in this case?
Only in the sense that they both ran parallel, but the size of the one that Mr. Scheck showed me was twice as big, twice as wide as the ones on the envelope.
Okay, and you had that conversation with him this morning before you took the witness stand, correct?
Yes, he asked me to look at it, and I obliged him.
Now, the identicator kit uses large-sized pieces of paper, is that right?
Yes, it does.
And the Xerox pieces of paper that you were shown by Mr. Scheck today, of the test impressions taken by the jeans, were 8.5 by 11?
I saw them on the screen here and briefly when he showed them, and they weren't as large as the identicator pieces, yes.
Now, are you aware, sir, that Agent Diedrich made his own test impressions of the jeans with the identicator?
Yes, because I furnished it to him.
And do you know how he made his test impressions of the jeans?
I wasn't present when he did that.
Do you know whether LAPD took impressions of the jeans in many different ways?
Again, I wasn't involved in that aspect of it. As far, if Agent Diedrich had any information about that, I'm not aware of it.
Question is with that foundation.
No, he said he didn't know about it.
Well, but I object to the question being asked.
Do you have any information about the methods used by Agent Diedrich to make his test impressions of the jeans?
Do I have knowledge of how he did it?
Correct.
No.
Sir, would he be the appropriate person to ask about the way the test impressions of the fabric of these jeans were made?
With regard to
It's his opinion of another person's expertise.
With regard to the fabric impressions, Agent Diedrich would be the one that's qualified to know how known impressions should be taken and what is adequate or not adequate within the context of that examination.
So he would be the one to pose the questions to about whether the ribbing would have been spread out by rolling the impression or not, for
Yes, he would.
example. To your knowledge, was he ever asked such questions by Mr. Scheck?
Sustained.
Sir, if the test impressions of the jeans were made by merely pressing the paper on the jeans with your hand, would that make the space between the ribbing seem larger?
Again, I have not made all of these different types of fabric impressions because it's not my area with the identicator, only sock impressions that I use for a footwear-related type exam, so I wouldn't be able to answer that question. I haven't done a study or had experience in those different ways to know if there's a variation.
Agent Diedrich might know that, though.
Yes, he would.
Based on what experience you do have, sir, do you have any reason to believe that the rolling of impressions of the paper on top of the jeans would cause the ribbing to spread and appear more widely spaced?
Sustained. I sustain his objection to the same question.
She wants to open it up. I'll go into it.
No, we're not opening that up.
Okay.
We're going to finish.
Sir, do you have experience with cases where bloody shoe prints faded on just the day after they were made?
It's hard to answer that. I would say no because, I've seen impressions the day after they were made, but I don't go around comparing with a densitometer or something the exact fading of shoe impressions. I know they fade because I see that in my daily work, but I don't try to measure the amount of fade per day, so I wouldn't be able to tell that.
Well, have you seen impressions made in blood with shoes the day after they were made?
Yes,
Have you seen impressions made in blood with shoes a week after they were made?
yes,
2 weeks?
yes,
3 weeks?
yes.
So your experience and your opinion rendered in this case about the fading of bloody shoe prints, is that based on cases in which you've seen impressions the day after as well as years after?
That's correct.
Now, you were asked a series of questions by counsel concerning the conditions under which Dr. Lee did his examination of the Bundy crime scene. Do you recall that, sir?
Yes,
Do you know whether it's true that Dr. Lee had a time limit when he made his investigation at the Bundy crime scene?
Under knowledge, based on.
Do you have any
doctor's
idea?
testimony.
no, Your Honor.
Do you have any idea whether the defense ever asked to allow him into the Bundy crime scene again to complete his
Sustained.
investigation?
Sustained.
Sir, you indicated, you were asked a question, read a portion of your book about doing careful investigation in order to make sure that all shoe prints are properly detected. Do you recall that?
Yes, I do.
What is your opinion of the shoe print investigation done by LAPD in this case?
With regard to the photography, they did an excellent job. It's almost hard to recall many other cases over the year where both color and black and white photographs with that type of clarity were taken, with that many exposures taken. The only thing that they might have done in addition would be to have sprayed a chemical enhancement on those impressions. They may have darkened up some of the lighter ones slightly. The surface was very light to begin with. You don't get the amount of contrast change when it's already a light surface because you have dark blood or blood color on a light surface. It might have helped a little. And if, in this case, we had a pair of shoes from the suspect where we were looking for minute detail from cuts or scratches or wear, then it might have been critical to enhance those impressions. But in this case, we didn't. We were only looking for shoe size and manufacture, and the darker impressions were more than adequate, and any lighter impressions would not have made any difference.
As a matter of common sense, sir, if you have a series of shoe prints in blood, will they tend to get lighter as they go on in location, as they get farther and farther?
Yes, one of the things we do for preparation of classes is to, as bad as it sounds, it has to be done, is to step in blood and take steps down a tile flooring, and with each we number them, and with each step, the track, of course, becomes lighter and lighter. Normally, the imprint starts breaking up around between 6 and 8 steps, and usually after it gets to about 10 to 12, it's all but disappeared, and that would vary with the surface, the weight of the person, and the amount of the blood. But they disappear, become lighter with each step as they go along.
Now, you said it varies with the surface. For example, on concrete, that's a hard surface, obviously, correct?
Yes.
Has it ever happened in your experience, sir, that shoe prints will fade out to the point where they're not detectable on concrete, but then appear on a softer surface that might mold into the shoe itself?
Subjection scope.
Oh, well,
Could you be more specific?
Yes. In this case, sir, with respect to these fading shoe prints, did you make an observation as to whether these shoe prints faded out at some point along the Bundy Walk?
Yes, they did.
And approximately how far along the Bundy Walk had they gotten by the time they faded out?
Well, when they got up to what I had labeled L, M, and O, they were starting to just become pretty much non-existent. There were a couple thereafter, particularly if they went, and that could vary just with the weight. You could go a step and step lighter and not leave anything, and then the next step, if you really came down heavy, you might have a little evidence of it, and there were a couple beyond that, but pretty much around L, M, and O, they started to lose their appearance.
And was that about halfway down the walk, sir?
Yes, it was.
And then did you see a piece of carpet on the driver's side of the Bronco in which there was...
Sustain.
In that situation, sir, where concrete no longer picks up the details of a bloody shoe print, might you still find some transfer of blood from that shoe on a softer surface?
Sustain.
Does the non-enhancement of any of the shoe prints in this case have any effect on the reliability of your opinion that only one pair of shoes, the Bruno Magli size 12, was found on the walkway on June the 13th?
No, it does not.
Why not, sir?
If there were any other shoes that were at the scene, they would have left dark impressions, which became lighter and lighter as they also left the scene.
Now, sir, you were directed to testimony by Dr. Lee concerning the lines, parallel lines that you testified were actually not imprints but trowel marks. Do you recall that, sir?
Yes, ma'am.
Putting up people's, I think it's 598.
All right, this is a heavy one.
Yes.
All right, let Mr. Wooden handle it.
I believe the photograph you were directed to by Mr. Scheck is on the Defense Board 1337. Now, Mr. Scheck read the testimony of Dr. Lee from August 23rd, Wednesday. I'm going to read you the testimony from August 22nd. Is that this?
You have a page in that.
My real time says 2:46 on it.
I just show it to Mr. Scheck.
Yes. I will do this, Your Honor. I'd like to wrap it up.
Well, Ms. Clark, we're within a couple of minutes, but it ought to be the actual transcript, since we can, so that the reference to the record can be made.
We don't have the Now, you were shown 1337 B, correct? By Mr. Scheck? Recall this one?
Yes, I was.
And with respect to this imprint, sir, there was an aspect of the imprint shown, of the lines shown to you here, that you determined was made in concrete.
That's correct.
And could you point that out to the jury, please?
Yes, this is the wavy lines up between the ruler and the obvious heel mark.
And do you recall Dr. Lee's testimony, sir, discussing that particular set of lines as an imprint?
Yes.
In your opinion, sir, is it misleading to discuss something as an imprint that is made in concrete?
Well, if I could explain,
Yes.
the only thing misleading is, as I perceived the discussion, in some context, Dr. Lee, and this is over his testimony, was pointing to things that,
Generally, and is not responsive, should be directed towards the
Ask a
specific
specific
testimony.
Let me ask you this, sir. Do you recall that on one day of his testimony, August 22nd, on Tuesday, Dr. Lee referred to the photograph taken and shown on the far left as you face the photograph entitled Walkway 612, referred to lines in that tile as possible imprint?
yes,
And do you recall that he did not correct or qualify that conclusion until he returned to court the next day, August 23rd?
I believe it was the next day, yes.
And in your opinion, sir, and then at that point he qualified it as being possibly the result of a trowel mark in the tile, correct?
Yes,
But until that next day, he left the jury with the impression that that might be an imprint.
Sustained.
And your opinion is, sir, with respect to the lines on that tile, is it a possible trowel mark or a possible imprint?
no, it's positively a trowel mark.
And you have no doubt about that?
There's no doubt about it. I've felt it with my bare hands and photographed it.
Sir, with respect to the parallel lines on the jeans and on the paper and envelope and on the walkway, are the parallel lines in those three areas, and I grouped the envelope and the paper together, then the jeans, and then the walkway.
Yes,
Are the parallel lines in those three areas similar to each other?
no.
Why not?
In differences of spacing and breadth of the lines and other features. Of course, on the biggest obvious difference is on the walkway, it's probably a shoe print. On the jeans and on the envelope on the paper, in my opinion, it's not even a shoe print, so that's the biggest difference. But if you were just to compare the features of the parallel lines, they are also different.
And is it important, in your opinion, to point that out to the jury, that there's a different mechanism for the imprint that was made on those three areas?
Yes, it is.
And why is that?
So they have a full and clear understanding of what caused those items or what features in those items were significant.
Now, you agreed with Mr. Scheck that you did not say 1337A and B, the lines that are outlined, that are circled by Dr. Lee, were in concrete.
That's correct.
They were not in concrete.
No.
And your testimony with respect to those impressions as to whether or not they were there on June the 13th at all was?
In my opinion, well, with regard to the little parallel lines in the corner of the tile that we have very good photographs of, in my opinion, they absolutely were not there. With regard to the other shoe impression, my opinion is also they were not there, but for several reasons, not for just one, like a photograph.
Now, you indicated in response to Mr. Scheck's question that in a very loose sense you could look at it if you were asked to say that various imperfections in the tile could not be excluded as other footwear impressions. Do you recall that answer, sir,
No.
in the loose sense?
Misstates that was his testimony.
Yes,
Sustained. I'm sorry, overruled. Last question, though.
it is. Do you recall that? Your
I'm
answer
sorry,
in
I
that
thought it
regard,
was
sir?
sustained. Could you restate it, please?
You gave an answer that in a very loose sense, you could look at it, and I believe you were referring to the walkway. If you were asked, or anyone, including Dr. Lee, to look at this and say, there are various other imperfections in the tile that could not be excluded as possible footwear impressions. And you indicated, of course, you couldn't. Can you explain to us what you meant by in the very loose sense?
Yes, and looking at the overall photograph, which
And referring you back to People's 598.
in looking at the overall photographs of the walkway, as well as the various respective tiles that we have of the close-ups, and looking at all of the evidence with regard to footwear impression evidence, you can see, particularly on the overalls, many discolorations and different shadowing and marks. You can just take every tile and see something that's ununiform about it. But none of them, in my opinion, have any shape or are caused by shoe prints other than the bloody Bruno Mali prints to which I've testified and which are much clearer to see. So the fact that the tile has numerous trowel markings and miscolorations on it, that's basically what I see. I don't see any evidence from these photographs of other shoe impressions.
Thank you,
In-
and I have
in
nothing
blood.
further, Your Honor.
All right, ladies and gentlemen, we're going to take our recess for the noon hour. Please remember all my admonitions to you. Don't discuss the case amongst yourselves, form any opinions about the case, conduct any deliberations till the matter has been submitted to you, or allow anybody to communicate with you with regard to the case. We'll stand in recess until 1 o'clock. And let me see Ms. Clark and Mr. Cochran just for a moment.
Please clear the court.
Here again, present. All right, Deputy Trier, let's have the jury. I'm sorry, Mr. Kilburn.
Just very quickly, Your Honor, Mr. Yokelson informed me that shortly before the noon hour he came down, and I'm not sure if it was a direct communication with the court, but the response I got was we had requested to allow Mr. Marks the opportunity to review the transcript of the interview with Dr. Whitehurst in order that we may ascertain his views of the allegations that are made. The allegations, just for the most part, do not directly pertain to anything Mr. Marks did in the Simpson case. They deal with other allegations. And that not to allow Mr. Marks the opportunity to review what these allegations are and to give us his perspective on these allegations obviously is, in our judgment, quite unfair, for we have no idea of how much of a mini-trial there would have to be regarding the allegations. Separate and apart from that, as the court is probably...
So the bottom line is you're asking for the opportunity to make an additional copy of the transcript.
And submit it directly to Mr. Marks for him to be able to comment upon it to me.
Well, we object. We intend to use that for impeachment, and there are specific things about this case that's just not accurate. There was a lot of discussion about this case, and there are memos about this case, so we will be cross-examining or asking further questions of Agent Marks about his truthfulness in this case.
Your Honor, I don't think that's an accurate characterization, but whether or not I'm correct on the percentage or Mr. Blazier is, this is the equivalent, in essence, of an expert's report, Dr. Whitehurst's report, and
All right, is
I
the
don't
matter
know what...
submitted?
Yes,
Granted.
thank you, Your Honor.
Restricted to one copy.
Thank you, Your Honor.
All right, Deputy Trier, let's have the jurors, please.
Filing a motion for request for judicial notice that we're going to ask the court to give before we conclude today. And so at the conclusion of Mr. Boziak's testimony, other than
I
that...
hadn't given waxing or waning yet either.
No, I know.
I know, okay.
So we have some more to add to that. We're filing it with the court now. Defense will get a copy. Before we conclude today, we need to be heard on that so that we can wrap it up.
All right, what's the nature of the request for judicial notice?
There will be a request to have the court take judicial notice. This is pursuant to Henry Lee's testimony, Your Honor, that the defense never sought a court order for inspection of the socks between November 22nd, on the date they were returned from DOJ, and February 16th, the date that they actually did inspect it. They never sought a court order for inspection of the Bronco or complained to this court about the sufficiency of their access to the Bronco. They never sought a court order for inspection of the Bundy crime scene or complained...
Got the
Get it.
flavor. Seated. And Mr. Boziak, would you resume the witness stand, please? All right, good afternoon again, Mr. Boziak.
Good afternoon.
All right, Ms. Clark, have you concluded your redirect examination? Ms. Clark?
I'm sorry, yes, Your Honor.
All right.
Completed redirect.
Mr. Scheck?
Thank you, Your Honor. Good afternoon. Just a few questions, Agent Bodziak. Ms. Clark asked you on redirect examination about, she asked you, can anyone examine what's obscured? Do you recall that?
Yes,
And she asked you if you based your opinion about the parallel line imprints on what you could see and not on what you couldn't see.
that's correct.
And you said yes.
Yes,
Now, was not part of your opinion concerning the parallel line imprint evidence on the envelope and the piece of paper based on the fact that you did not see a border?
that's one part of it, yes.
Well, that's something that you did not see, correct?
The fact that I did not see it is the whole point, sir.
Well, you said just a second ago you based your opinion based on what you could see, not on what you can't see. Didn't you?
Absence of characteristics is the significance here.
Now, would you not agree that there are blood stain impressions over the parallel line imprint on the piece of paper?
Yes, there are.
And Mr. Scheck, you're making reference to a particular exhibit that's before the jury.
1338.
Right, making reference to the upper left-hand photograph.
And there are also blood stain impressions over the area of the parallel line imprint on the envelope.
Yes, I'm well aware of that.
And with respect now to, you gave a testimony on redirect examination that you based your conclusion that the imprints on the jean did not come from shoes based on the manner in which the imprints appeared on the shoes.
I'm not
On the
sure.
jeans, I'm sorry.
No, it's based on several things.
You don't recall that question on redirect?
I don't recall the exact quote. My answer is based on many things. If you asked me, was it in part based on that, I would have said yes.
Okay. Now, you indicated on redirect examination that the use of the identicator kit to make test impressions and to draw conclusions about imprints on the jeans from fabric was Agent Diedrich's area.
With regard to the fabric impressions, yes.
And you would rely on his expertise in conducting that examination.
He would do it independently. I wouldn't rely on it. He doesn't come back to me and report to me, and then that is a basis for my opinion. He does that independently and reports that independently.
But I think that Ms. Clark's question to you on redirect examination, that's not your area, that's his area.
That's correct.
And are you aware that Agent Diedrich testified that as far as he could remember, he had never done such an analysis before of bloody imprints on fabrics?
Objection, that mistake.
Sustain. Phrase the question.
Are you aware of what Agent Diedrich said about the amount of experience he had in terms of doing analysis of bloody instruments, imprints, fabric on fabric?
Irrelevant.
Oral.
I did hear that part of his testimony, yes.
Okay. Now, on redirect examination, you complimented the Los Angeles Police Department, saying that they had done an excellent job photographing imprints at the crime scene
That's correct.
because they made both color and black and white.
And the manner in which they took them and the quality of the subsequent photographs that they developed.
But, Agent Bodziak, in your book, you emphasize before beginning the crime scene search, careful thought should be given to what occurred at the crime scene, how footwear impression evidence could contribute to the proof of fact, and what areas of the crime scene might contain impression evidence. Then footwear impressions should be looked for aggressively and carefully. What is not looked for will not be found. You agree with that?
Asked and answered.
You agree with that?
Absolutely.
Now, based on, have you reviewed the testimony of Dennis Fung, Andrea Mazzola, Detective Lang, as to how the Bundy crime scene was processed?
Objection beyond the scope.
I have some knowledge of that, yes.
Do you feel that you're in a position to say that they did an excellent job in giving thought before they began the crime scene search to what could have occurred and how footprint impression evidence could contribute to the proof of fact, and aggressively searching out footwear impressions?
Yeah, they knew what the crime was. It was quite obvious. They could see bloody shoe prints leading from an area which was almost totally covered in blood. They, as far as I remember from their testimonies, looked for other evidence of shoe marks, and they did their best to preserve it. And they ordered that it be photographed and recorded, which it was. As to anything else that went through their minds that they didn't state, I wouldn't be able to testify to that. But from what I heard, that's exactly what they did. They made a point of looking for footwear impressions. There were those that were obvious, and they also looked all the way down the walkway, documented them all the way to the end in the back of the residence, and photographed everything that they could see.
Agent Bodziak, in terms of, you didn't read their transcripts, right?
I haven't read anybody's transcripts.
All right. And what percentage of the testimony of Fung or Mazzola or Detective Lang with respect to how they sought out and examined footwear impressions do you think you heard?
Objection argumentative.
Sustained.
What percentage of their testimony do you think you heard?
Objection argumentative.
Sustained.
How much of their testimony did you hear?
Objection argumentative.
Let's not get into this.
You feel comfortable, based on your knowledge of what occurred at this crime scene, that you can tell this jury that they did an excellent job in aggressively seeking out latent and or nearly invisible footwear impressions at the Bundy crime scene? You feel comfortable with that?
Objection, Your Honor.
Overruled.
Nearly invisible?
Overruled.
Of course, Mr. Scheck, if there were any invisible footprints at the scene, certainly they could have missed them. The point is, they would not be invisible if they were in blood. You wouldn't have a footwear impression, for instance, the one in parallel lines on tile 10 that was in blood 10 tiles down with no other parallel line footwear impressions before it. It's impossible unless the person that committed the crime can fly. Mm-hmm. And there's no way for them to have walked through that blood and not leave other impressions. And with the tiles that they photographed, with the general scene photographs, there's no evidence of any other footwear impressions.
Agent Bodziak, you say walk through the blood, right?
That's correct.
You are referring to the pool of blood that was on the walkway that appeared to have come from Nicole Brown Simpson.
Yes.
In fact, when you were asked questions on redirect examination about whether or not there could be other imprints from shoes, you said no, because they would have left dark impressions. You recall that on redirect?
Would have left darker blood impressions, yes.
Darker blood impressions,
Yes.
right?
Yes.
And that, again, is based on the assumption that somebody would have to have walked through the crime scene, stepping through the pool of blood on the walkway that was left by Nicole Brown Simpson.
That's correct.
And that is based further on the assumption, sir, that somebody who was involved, or person or persons involved in this crime, would necessarily have had to walk through that pool of blood.
If they were at the scene of the murder, since I have been to the scene, and I believe everyone else has, it's so small, so confined, combined with the fact that people do not consciously think of what they're walking in on an everyday basis, much less under that kind of a stressful situation, they would not have been able to be at that scene involved in the murder without walking through that blood and leaving evidence of it.
Agent Bodziak, ask you to assume that a struggle occurred with more than one perpetrator with Ronald Goldman, and that one or more of those perpetrators left the scene before Nicole Brown Simpson's throat was cut, causing that pool of blood on the walkway. Do you have that in mind?
Objection, Your Honor, it's improper hypothetical, since facts not in evidence.
Do you have that in mind?
Are you asking me to isolate that thought for a moment?
I'm asking you to keep that thought in mind.
I'll keep it in mind.
Now, if that occurred, one or more perpetrators could have left the crime scene without walking through that pool of blood.
Are you suggesting there were two independent murders at the same place, 10 minutes apart?
Oh, is that necessary for this hypothetical?
It seems to me that's what you're suggesting, that there was one person that might have murdered Ron Goldman and then left the scene, and then along comes somebody else and murders Nicole Brown 2 feet away. That's not the way I understand it.
I'm only asking you to make this assumption, that the murder of Ron Goldman occurs, and then, as among the last things done at the crime scene, the throat of Nicole Brown Simpson is cut, causing the pool of blood on the walkway. Can you keep that in mind?
I can keep it in mind, yes.
Did you hear 8 days of testimony from Dr. Lakshmanan, which included that hypothetical?
No objection, that mistake.
Sustained.
Now, if that were to occur, could a perpetrator or perpetrators have left the crime scene without walking through that pool of blood?
In this case, I don't believe that's what happened, but if you're to suggest that I consider it under your hypothetical where there was one murder and later another one, I suppose that it could, but I don't believe that's what happened.
You don't believe that's what happened?
No, sir.
You weren't there, were you?
Objection, I read it.
Sustained. Rephrase the question.
The imprint evidence, the bloodstain imprint evidence that Dr. Lee discussed, that whole board, you don't recall that testimony.
Objection vague.
Sustained.
Do you remember an analysis of the order of deposits on the envelope that Dr. Lee made in his testimony?
I previously testified that I did not see that part.
Right. Well, would it not be consistent with the hypothetical I posed to you that there were a set of imprints made at the crime scene that were partial, based on less blood flow, somewhat less blood flow than the pool of blood?
No, I don't think that the sequence, the fact that there may be an imprint and then later blood would flow on the envelope or may get moved and acquire other blood in one manner or another would have anything to do with my exam of the imprint.
Mm-hmm. But wouldn't it be a fair statement that your answers to my questions here and your statement on redirect examination, that if there were other imprints from shoes, bloody imprints from shoes, that the impressions would have to be dark, is based on your assumption that the perpetrator or perpetrators of this crime would of necessity have to have walked through the pool of blood on the walkway?
It's based on my visit twice to the crime scene, my view of volumes of notebooks of photographs of the crime scene, my examination of the quantity of blood on the walkway, the distance that a person would have to jump if they, for some reason, were conscious of footwear impressions, which they're not, and all of the other factors. In looking at crime scenes over the years, with that kind of scenario and that kind of confined area, a person that was in that area would leave bloody shoe impressions. They would be first dark and then get lighter as they walked away.
Well, all of what you've just said is based on the assumption that somebody would have to walk through the pool of blood caused by the severing of the neck of Nicole Brown Simpson, right?
That's been answered.
Overruled.
Of course it would, yes.
All right. Now,
you were asked on redirect examination about the parallel line shoe print impression that Dr. Lee identified as a shoe print, which he found on June 25th.
Is that the one on the 10th tile?
Yes.
I believe. Yes.
All right. Now, could we play 10, 11? You,
Can I see what counsel's proposing?
this is the, do you recall, I'll preface it this way. As part of the examination of Dr. Lee that you saw, do you recall a time when Mr. Goldberg played a tape of two police officers breaking down the Bundy crime scene?
Yes, I recall seeing that.
All right, could I play that?
Yes. Which exhibit is this, Mr. Harris? Overruled.
There's more? Okay. Agent Bodziak, you collected the shoes of officers that were present at the crime scene.
There were photographs of some of the officers sent to me to view with regard to what design shoes they had on.
And this thing also included the photographer, Mr. Rokar?
I believe so. It's been a while. I'd have to go back and look at the officers' names.
And would it be your testimony that none of the shoes that you were given of people that were involved in the crime scene would match the parallel line imprint impressions of the shoe print Dr. Lee identified on June 25th?
No, that's correct.
Have you been shown by the prosecutors a videotape of the inside of the Bundy residence where candles are lit?
Not by the prosecutors. I think I saw something like that on the news one time.
Mm-hmm. Have you been provided any other shoe prints from other people that might have been at the crime scene on June 13th for comparison to the imprint that Dr. Lee identified as a shoe print on June 25th?
None other than those of the officers that were submitted to me.
And it's your testimony that they could not have accounted for that imprint?
That's correct.
I have nothing further.
Clark?
Yes, briefly.
Mr. Boziak, do you know whether or not the shoes of the officers depicted in that clip that you were shown, Defense 1011, were ever photographed and shown to you?
I don't know the identity of the officer in that clip, so I don't know if they were one of the officers whose shoes were submitted to me or not.
And you don't know whether all of the officers who ever walked through the crime scene between June 13th and June 25th shoes were shown to you in photograph form either?
No, I do not.
Were you aware that the film clip you spoke of showing the candles burning through the window was taken by a cameraman from a TV station?
I believe when I saw the news clip that the reference was made to that. Yeah.
And so you would have to go and locate who that videographer was and see if he could remember what shoes he wore in order to determine whether his shoes made that imprint. Would you not?
That's correct.
And do you know whether the family of Nicole Brown was present at that Bundy walk and walked on that Bundy walk between June 13th and June 25th?
I don't know that.
Did you ever see any film clips that showed a number of people crowded around the 875 Bundy location on June 17th?
I'm not familiar with that, no.
So if there were a number of people that were walking up and down the walkway in Bundy between June 13th and June 25th, you would have no way of knowing whether it was one of their shoes that made that wavy line imprint that was on the 10th tile.
No, I would not.
And the wavy line imprint made on the 10th tile was photographed on
Strike. This has nothing to do with the wavy line imprint.
the parallel line imprint.
All right, so we're clear.
And the parallel line imprint that was the one photographed on June 25th by Dr. Lee, correct?
Yes.
Did you, and that was that a fairly faint imprint, sir?
Yes, it was.
Did you see any darker imprints of that type preceding it on the Bundy walkway?
No, none on any of the other tiles or in any of the other close-up photographs or any photographs that were taken at that scene.
And what does that lead you to conclude about the appearance of that, about the materialization of that imprint on the 10th tile on June the 25th?
I would not be able to determine a scenario where a person after the fact or during the crime stepped in blood and left only a footprint proposing it's in blood. I'm just hypothetically saying in blood on the 10th tile and nowhere else. It's impossible.
Then in your opinion, sir, was that parallel line imprint on the 10th tile that was photographed by Henry Lee on June 25th, was it even present on June the 13th?
In my opinion, it was not present.
Does it have any significance to the solution of this murder?
I don't believe so.
Thank you, sir.
With respect to those officers you saw in the videotape, in the ordinary course of your work, wouldn't it be the responsibility of the prosecutors to provide you with the footwear impressions of all police officers that were involved in the crime scene?
Objection, Your Honor.
Sustain.
Were you were sent a whole series of footwear impressions from the Los Angeles Police Department?
No. Pictures of shoes.
Pictures of shoes?
Yes.
All right. And the purpose of showing you the pictures of those shoes was to provide you with essentially a set of eliminations so that one could distinguish impressions made from people that were processing the crime scene versus other people that might have been there previously.
In this particular case, because of the large quantity of blood, they were sent for elimination to make sure that no one else had that Bruno Magli design.
All right. And you don't know whether those two officers were ever sent to you?
The ones in the videotape?
Yeah.
No, I don't know the names of the individuals in the videotape.
And the prosecutors never sent you any other footwear impressions of people that were at that crime scene between June 12th and June 25th?
No, they did not.
Thank you.
Ms. Clark?
Sir, if police officers walked on the walkway after the photographs of the shoe prints were taken, then by definition their shoes could not have made the Bruno Magli shoe prints that you identified, correct?
No, their footwear impressions would be irrelevant to the crime.
I have nothing further.
Thank you. Mr. Bosiak, again, thank you very much, sir. You were excused. All right, anything else from the people?
Only the very brief matter that I mentioned to the court.
All right, you did ask the court to take judicial notice of one other matter regarding the phase of the moon.
Yes, I did, Your Honor.
All right, do you want me to do that at this time?
Certainly, Your Honor. Thank
Any
you.
comment, Mr. Cochran?
With regard to the phase of the moon?
Phase of the moon?
No, I don't think so. I think,
Right. We discussed this earlier.
we'll go.
Right. All right, ladies and gentlemen, the prosecution has asked the court to take judicial notice of a certain fact, and what that means is that if I determine that it's appropriate, this is a fact that is not subject to dispute, and I have agreed to take judicial notice of the following fact, that on June the 12th, 1994, the moon was a waxing crescent with 12% of the moon's surface illuminated. All right, I'll read that one more time. On June the 12th, 1994, the moon was a waxing crescent with 12% of the moon's surface illuminated. All right, Ms. Clark. Anything else from the people?
We have the one further request of the court that I think can be resolved quickly, and then the people would like to conditionally arrest the rebuttal case.
All right. Let me ask the jury then to step back into the jury room. I'll just have a legal discussion with the lawyers for a few moments, and then hopefully we'll be able to conclude with the prosecution's rebuttal case. All right, I have a request for a permissive request for judicial notice. Ms. Clark.
As we've indicated,
If I may, just to maybe short circuit this, we just received this. It contains transcript sites. We have to search the record to check the dates. We're not prepared to respond to this at this time.
When you say you just received this,
I mean, I just received this. Got this.
5 minutes ago, 20 minutes ago?
I don't know when you first chatted. It was today. He just chatted.
Yeah. I mean, this is,
5 minutes ago, 20 minutes ago?
well, I saw this 2 minutes ago,
All right.
and it's my job to respond to it. I'm not prepared to do it, and because it has citations that I have to check, and there's a long record here. There's numerous applications going back and forth. I have to check the date of who had access to the SOX when and what the orders were. I think Dr. Lee's testimony speaks for itself as to what he knew and what he did. If they want to call other witnesses about something else, they can. But the point is that I'm not prepared to argue this at this time and accurately cite to the record. And it would be unfair to ask you to do so.
When will you be prepared to do so?
Tomorrow.
9 o'clock. Does contain citations to the record.
it does, it's true. We got a lot else we can do anyway, so.
Indeed, we do. All right, Mr. Cochran, assuming that the prosecution rests their case at this point, and I've indicated to them that I'm going to allow them to conditionally rest because you have not concluded your defense case. You know how that goes? All right. Do you have any other witnesses you're prepared to present this afternoon?
Yes, I'd like to proceed right away, and I would like the court's indulgence because some of the witnesses who might technically be in our case in chief, we can't get to until tomorrow probably. So we'd like at this point to call Dr. Herb McDonald, who might be more nearly characterized as a cerebral witness, but we'd like to call him now. We're ready to proceed.
All right, this is as to what issue?
Primarily as to the glove drawing, glove shrinkage, in light of the testimony of Mr. Rubin when he came back here in the rebuttal case.
What are we going to get into? We're going to get into our glove experiments?
Yeah, the glove experiment, which you've already passed on and authorized.
Obviously, this has got to be part of the defense rebuttal, correct? I don't know what it relates to in terms of Mr. Rubin's testimony. How's it relevant?
Well, Mr. Rubin testified that when he looked at the gloves that Mr. Simpson was wearing initially in 1990 and wearing up until December of 1993, I believe, he testified that, in fact, I think he testified that the gloves appeared in the pictures to be somewhat bigger even in 1993 than they were in 1990. That, in conjunction with his earlier testimony back in June of this year, leads to the clear inference that the substantial shrinkage that occurred, which he said was about 15%, was due from the blood being soaked and smeared on the gloves during the night that these two people were killed. It would have been somewhat suggested before that that could have been the result of weather. But since we saw Mr. Simpson wearing these gloves in a number of pictures where it's raining on them, where it's snowing on them, where it's sleeting on them.
I don't think we ever saw snow or sleet, but we did see a lot of rain.
Okay, a lot of rain, and it was very cold rain. And discussion of hand warmers and the like, but nonetheless, the gloves were at least as large at the end of '93 as they were in December of 1990. Then the inference, unmistakably, that the prosecution will be arguing is that this 15% shrinkage occurred as a result of the events of June 12, 1994. And so he will be testifying to his glove drying experiment, which deals with substantial quantities of blood being smeared on the gloves to show that that's just not right.
All right, my recollection is, did we have a videotape of this, or was it still photos?
No, it was still photos, and which were given to the people and given to the court. We had a hearing on the admissibility of this evidence, and you ruled that it was admissible.
All right, Ms. Clark, who was it Mr. Goldberg who was handling this? Ms. Clark.
I thought, okay, it was my recollection of Mr. Rubin's testimony, Your Honor, that he testified it was a combination of the weather conditions to which gloves would be subjected, as well as perhaps the introduction of the blood with the freezing and the drying and the unfreezing, et cetera. But the issue is really not shrinkage as much as it is stretchability. And I don't think that anything Mr. Rubin testified to in the People's Rebuttal case opens up that issue for Mr. McDonnell.
We did discuss, however, the issue of shrinkage during the course of Mr. Rubin's third appearance as a witness. And we discussed it in terms of the weather conditions, in terms of rain, and in terms of the heat generated by hand warmers, if such were the case. So we did discuss it during shrinkage during the course of, and if you recollect, the argument is that the defense also withheld, for tactical reasons, presenting Dr. McDonald on this shrinkage experiment, so as to hope to preclude Mr. Rubin from coming back and testifying again. But
well, that was their reason. I don't think that has.
I understand, but I'm just putting our discussions back into context.
Mm-hmm. And I understand that, but the court's characterization is, of course, correct with respect to Mr. Rubin's testimony and the being subject to weather conditions, but it had nothing to do with shrinkage caused by the introduction of blood on the gloves. And that's the subject matter of the glove drying experiment that Mr. McDonnell performed. So it's not relevant to rebuttal, because we are talking apples and oranges. Mr. Rubin talked about the weather conditions to which the glove was subjected. Mr. McDonnell proposed to talk about what will happen to the glove as a result of blood. And it's two different things.
But I think the point, though, that Mr. Neufeld is trying to make is that soaking in blood can't account for the amount of shrinkage that we see here. And that if it fits Mr. Simpson, apparently as it does in the videotapes, as well as it does then, it may not be the same pair of gloves now, since this one that we have in evidence appears to be shrunken by 15%. I think that's the inference that they're trying to draw here.
It is, but is it a fair inference, and is it fair? Is it on point in terms of Sir rebuttal in view of what we introduced in our rebuttal case? It's not the same thing. If you talk about subjecting to weather conditions, fine. Let Mr. McDonnell testify that he's a glove expert and he knows what the fat liquor and all the other aspects of leather are going to do when they're subjected to weather conditions. But it certainly has nothing to do with the introduction of blood. I mean, we are talking apples and oranges here, so I don't see the relevance.
All right.
In addition to what kind of gloves did he test?
My recollection, though, is that he did the glove experiment on one of the gloves that were from...
He did the experiment on the gloves that Mr. Rubin provided, which are the Aris Isotona lights, the same exact pair of gloves that Mr. Darden used for his second glove demonstration with new gloves.
All right, I'm going to overrule the objection. Ms. Clark, do you have your materials?
No, I don't.
All right. Why don't we take a recess then until 2 o'clock, get your materials, and then we'll reconvene. I'll allow you to rest conditionally in front of the people's rebuttal case, subject to application, should it become necessary to reopen, and then we'll proceed.
I just wanted you to also know that in light of, I've also had Professor McDonald listening to Mr. Bodziak's testimony, and he may also be rebutting certain things he just heard Mr. Bodziak say this morning. I'm talking to him at this moment about those things.
Well, before we launch into that, we'll have a hearing outside of the jury, outside the presence of the jury, just to see where we're going on that.
Fine.
All right? Okay, 2 o'clock. All right, are we ready to proceed?
Yes, I may need a slight break between cross, thank you, Anna.
All right. All right, Deputy Charles, let's have the jurors, please.
It was difficult to locate all these materials because we...
I understand. Not to worry today.
On the discovery I have pertains to an experiment. I wanted to propose a brief 402 with Mr. McDonald concerning the experiment he conducted here, and that would be with respect to the gloves that he performed the experiment on. The discovery I have pertains to an experiment done on thin-slate gloves. None of my discovery shows the performance of the experiment on the Aris-like gloves. All I have is a letter.
Deputy Chair, hold yours. I'm sorry, I thought we were talking about Aris leather lights. Hold them for just a second. That's my recollection.
The recollection is 100% correct, number one. Number two, they received complete discovery, including photographs of the actual experiment conducted by Professor McDonald. They received the notes of the experiment conducted by Professor McDonald and the report of the experiment conducted by Professor McDonald. And it was absolutely unambiguous that it was the Aris isotona light gloves that had been furnished by Mr. Rubin.
Leather light.
Leather light.
I think as soon as you throw an isotoner, you get in synthetic materials here. The Aris leather lights were all natural materials with the exception of the
Leather
thread.
lights, I'll refer to that.
Yep. Thinsulate is a synthetic insulation material.
And additionally, Your Honor, I wanted to do a brief 402, question Mr. McDonald outside the presence of the jury to determine what other gloves, for the preparation of his testimony, in this case, he examined or tested, and whether or not he tested the gloves depicted in the photographs that we've shown to Mr. Rubin during our rebuttal case, or our reopened people's case, however you
Mr. Neufeld, anything else about any other gloves that he's tested?
The only gloves that the experiments were conducted on are the B gloves that were provided by Mr. Rubin, period. That's it.
And does Mr. McDonald intend to testify in any manner to the gloves that are depicted in the photographs shown to Mr. Rubin?
He hasn't done any experiments on that.
Meaning the evidence gloves.
Correct.
Right. I don't think he's done any, those have not been taken out of evidence for that purpose, I don't believe.
Oh, no, and I meant in the photographs shown to Mr. Rubin as well, the ones that we've presented most recently at the football games.
I think I made it very, very clear the extent of his testimony.
Yes, I think so. I've already ruled on this
Okay.
previously.
Is Mr. McDonald going to testify in any manner to the location of the gloves shown in the football game photographs, or their condition, or their fit, or anything like that?
No, I think the offer was the experiment.
If that's the indication, then may I ask that the court order Mr. McDonald to offer no explanation or no testimony pertaining to the whereabouts of the gloves in the photographs?
Well, I don't
As it
think we're
would be
getting into
hearsay.
that. We're talking about an experiment with regards to the Aris leather lights, correct?
Providing expert testimony. He's not providing lay testimony about other matters.
All right, thank you. Deputy Trower? After Mr. McDonald, Mr. Cochran.
Police officer, I'm sure you're ready. Next witness.
I need to be heard on that one, Your Honor.
All right. No, I just asked the question. Let the record reflect that we've been rejoined by all the members of our jury panel. And Ms. Clark, with regards to the people's rebuttal case, what is your position at this point?
At this point, Your Honor, the people will conditionally rest rebuttal subject to the matters the court is aware of.
All right. People having rested their rebuttal case. Mr. Cochran?
Yes, we're ready to proceed, Your Honor, with balance of our case and some small bits.
All right. Mr. Neufeld?
Thank you. This time, Your Honor, the defense calls Professor Herbert McDonald.
All right. Mr. McDonald? Recall.
Recall?
Recall.
Okay.
All right, Professor?
Raise your right hand, please. You do solemnly swear that the testimony you may give in response to any before this court should be the truth and whole truth and nothing but the truth, so help you God?
I do.
Please have a seat and state for your first and last names for the record.
Herbert Leon, Leon, MacDonald, capital M-A-C, capital D-O-N-E-L-L.
Thank you. Good afternoon, ladies and gentlemen. Hi. Hi. Professor McDonald, did you have an opportunity to watch on television portions of the testimony of Mr. Rubin, who testified about Aris leather-like gloves?
Yes, I did.
And did you have an opportunity to watch his testimony back in June of this year, as well as more recently, perhaps a week ago?
More recently, I don't recall it in June. I wasn't here in June. I
But
was
did you
in
review,
Alaska.
I'm sorry, but did you review some of his testimony, though?
I'm
from back-
familiar with it. I did not review it in detail.
Okay.
Excuse me, gentlemen. Professor, would you allow Mr. Neufeld to finish asking you the question before you start your answer, as the court reporter is going to have a difficult time?
I'll try.
Thank you, Professor.
And as you sit here today, sir, are you aware that Mr. Rubin testified that both the Rockingham and Bundy gloves are approximately 15% smaller than our new standard extra large Aris leather-like gloves?
Yes, I'm aware of that.
You remember that 15% figure?
Yes, I do.
Okay. And sir, did you also watch on television last week when Mr. Rubin was shown photographs of Mr. Simpson wearing brown gloves at NFL football games?
Yes.
And were you aware, sir, as you sit here today, that Mr. Rubin testified that, if anything, the brown gloves that Mr. Simpson is wearing in December of 1993 appear to be somewhat bigger in the photographs than the brown gloves in 1991?
Objection, that is
No?
Sustain. Rephrase the question.
Well, sir, did you have a chance to actually look at those photos yourself?
Yes, I have.
And would it be fair to say from the photographs there is no evidence of any visual shrinking of those gloves?
Sustain. Foundation.
Now, did you conduct an experiment to determine whether or not smearing Aris leather light extra large gloves with a considerable amount of blood would cause 15% shrinkage?
Yes, I did.
And did you also conduct an experiment to determine the approximate drying times of gloves that had been heavily smeared with blood?
Yes.
And,
Sustained. Sustained. Drying times. Proceed.
okay. Your Honor, may I have a-
Shrinkage. No. Shrinkage.
May I please have a sidebar? I think there's a distinction. I just want to make it at the sidebar, if I may.
I thought we already made the distinction very clear the last time we talked about this.
I think there's a slight difference, if I may.
With the Goldberg.
I have 1 minute to.
Certainly.
Thank you.
All right. Thank you very much, counsel.
Professor McDonald, to conduct this experiment, did you receive from the defense a pair of extra-large Aris-like gloves that had been provided to us by Mr. Rubin from the Isotona Company?
Yes, I did.
And were you aware of the fact that Mr. Rubin had stated that the gloves that you received for the experiment were identical in terms of make and model and size to the gloves from Bundy and from Rockingham?
Oh,
That is my understanding.
Okay. In other words, sir, did you receive extra-large gloves?
Yes, I did.
And were they Aris leather lights?
Yes.
And in fact, were you aware of the fact that the gloves that you received were identical to the gloves that Mr. Darden used in his second demonstration with new gloves involving Mr. Simpson?
Yes.
No foundation.
oh,
Now, would you please tell the ladies and gentlemen of the jury what you did as an experiment to determine the extent of shrinkage, if any, when gloves are heavily smeared with blood?
Yes, I took the gloves one at a time and put, for example, the right glove on my right hand and a rubber latex glove on my left hand. I had a laboratory technician draw a vacutainer of blood, and comparing that to a calibrated vacutainer, I knew how much blood was in that tube. I then poured the blood over the leather glove, cupping the palm upward, as I'm indicating, so it would hold the blood as much as possible. This was done very quickly, so there would be no clotting involved. There was no anticoagulant in the tube. This was a tube that just drew blood, and you must work rather quickly or it will clot. I then put the tube down and began smearing the blood with the rubber tips of my fingers. The reason for the rubber tips and the gloves in total, the rubber ones, was because I was going to alternate and put that hand in the left glove next, so I didn't want it wet with blood or anything else. I just kept smearing it around until it was running through my fingers of the glove and around the back, and I just kept doing that for approximately half a minute or more or less until I felt I was no longer working with wet fluid blood. This was over a very large funnel. The funnel emptied into a graduated cylinder, so I could determine the amount of blood that was recovered. Through an independent experiment, I found the amount of blood on the funnel was approximately 2 drops. So I knew the volume that I started with, the volume I ended with, the volume that was on the funnel, and therefore the approximate volume of what was on the glove, which was approximately 2 milliliters. And that was a very wet, surfaced, glistening glove. I immediately took it off and put one in a bag, which I sealed up, a plastic Ziploc bag. This was then repeated with the same arm giving blood again, and this time we had again approximately 9 milliliters of blood or thereabouts in the vacutainer, poured it over the other hand, repeated the process, caught the blood that did not adhere to the glove, and subtracting the amount of the blood on the fingertips and in the funnel, I concluded again it was about 1.9 to 2 milliliters of blood in each case. The amount that was adhering made the gloves very glistening and bloody, for want of a more descriptive term. And then this glove was also allowed to dry without being placed in a bag. These were both done very quickly, so there was no clotting of the blood on the surface of the glove.
Now, Professor McDonald, while you were conducting this experiment, was someone taking photographs of the procedure?
Yes, they were. And prior to actually doing the experiment, rather than measure the gloves, linear measurements with a ruler, I simply put the gloves onto a copy machine and do all these things at once and also keep a timing record.
Now, the gloves that are shown in the photograph, or the gloves shown in this photograph, is that the actual Aris Light glove that you received?
Yes, that's the right one in the current Elmo picture.
And sir, you said that the right glove was put into a plastic bag?
Yes.
And then did you repeat the same experiment with the left glove?
Yes, the same experiment with the left glove, and again I used the fingertips of a rubber latex glove to keep trying to get the blood to impregnate into the leather as much as I could. It wasn't just a light motion laterally, it was more or less pushing down in to try to saturate the external surface. Although it did not wet that well, it was certainly covered with blood and wet when I finished.
And you said you used approximately 9 milliliters of blood?
That's what I poured over it, but that's not how much remained on the glove. There was only approximately 2 milliliters.
And that would be the approximate amount for the second glove as well?
Yes, I think one was 1.9 and one was 2. I have those figures, but it's really not, it's an estimate because I did measure the blood on the funnel and estimated the thin film of blood on the gloves and added that to the amount of blood, or subtracted it from that which was used by adding it to what was recovered.
And by the way, sir, do you, in your opinion, would the results have been any different had you poured twice as much blood on these gloves as you did?
Difficult speculation.
That's sustained.
Do you have any basis for giving an opinion as to whether it would make a difference if you poured twice as much blood on the glove as you poured?
Yes.
And what is the basis for that, sir?
Well, the volume of blood I don't think is as crucial as the length of time. In other words, if I recycled it, If I just kept recycling it, I don't know how long it would be that I could do that before the blood had clotted into a gelatinous mass, and then that would dry on the glove as well. So if it's wet, and it won't hold any more.
You're not objecting, that was all speculation, no
No.
foundation shown.
Oh, well.
Now, with the second glove, after you conducted the experiment on the second glove, where did you place it for drying?
I placed the second glove on filter paper in a humidity chamber.
I'll show you photograph E. Ask if you can identify that. Could you please tell the ladies and gentlemen of the jury what is in photograph E?
It's a very large glass desiccator, and in the top part you can see the glove. That is the center, actually. You can see the glove. You can actually see the red blood on the glove. That's resting on filter paper. And filter paper is on a wire mesh that supports it above the slurry of potassium chloride, which is a wet slurry, a slushy mixture is the best way to describe it.
Did you make any effort, sir, to replicate the temperature and humidity conditions as they existed on the night of June 12, 1994, and the early morning hours of June 13, 1994?
Objection, call for speculation, foundation.
Foundation.
Did you, by the way, when you, in this special chamber, are you able to control the temperature and humidity?
Yes.
Okay. And to determine what temperature and what humidity to set for that drying chamber, did you review the official United States Department of Commerce Weather Service reports for Los Angeles Airport for the night of June 12, 1994, and the morning hours of June 13, 1994?
Objection, no foundation, no expertise, call for speculation.
Oh. Yes, I did.
I show you, sir, what is already in evidence as Defendant's Exhibit Number 1280.
Let's see. Speculation.
Oh, well, it's in evidence. I've received this already.
That's not. Beyond the scope of expertise.
Oh, well.
That's not true.
Proceed.
Thank you. We ask you to take a look at Defendant's 1280, sir. Do the U.S. Weather Service reports for Los Angeles Airport for the night of June 12, 1994, and the morning hours of June 13, 1994, from approximately 10:30 or 10, I think, I'm sorry. Are estimates for time and temperature given at a certain portion of each hour, at a certain point in each hour?
Yes, they are.
Is it, and what time is it given, is a measurement given?
It is usually given approximately 10 minutes to the hour, 9 or 10 minutes to the hour, being like 10:50, 11:50, and so on.
And sir, what did those official Weather Service records indicate was the range in temperature between approximately 10:50 p.m. on the evening of June 12th and 9:50 a.m. on the morning of June 13th, 1994?
The temperature range is 64 degrees Fahrenheit to 69 degrees Fahrenheit.
And sir, what was the temperature for your drying experiment that's depicted in this picture?
Sustained. Shrinkage experiment.
No, but,
What was the temperature inside the chamber?
okay. What was the temperature inside of the chamber, Professor?
69 degrees Fahrenheit.
And sir, do the records indicate what the humidity range was from 10:50 p.m. on the evening of June 12th till 9:50 a.m. on the morning of June 13th?
Yes, they do.
And what was the humidity range?
Respecting the interpretation of those records.
Mr. Counsel, sidebar with the record, please.
Professor McDonald, does the official U.S. Weather Service report that you have in front of you state what the relative humidity was at each of those different hourly readings?
Yes, it does.
And what was the relative humidity range from 10:50 in the evening of June 12th till approximately 9:50 in the morning on June 13th?
The total range was 72.7 to 81%, but I should point out this doesn't mean it starts at the low value and goes to the high value any more than the temperature. That was the maximum range. It doesn't mean the lowest temperature was the first reading. So it ranged in those, between those figures I've given.
And sir, what was the humidity that you set in your drying chamber?
I set the humidity, you don't set it. You use a system of chemicals to establish a constant humidity by which hygrometers are calibrated. And the nearest mixture that I could produce was 85%, which was slightly higher than the percent listed, but not from what I was first informed, which was in error. That was 85%.
And sir, on the official U.S. Weather Service report, is there a column which indicates whether or not there was any precipitation during each of those hours?
Yes.
And sir, at any time from 10:50 in the evening on June 12th through 9:50 in the morning on June 13th, was there any recorded precipitation?
There's so many columns here, I've got to find the right one. Pardon me. There was none. Zero.
And sir, during that same period of 10:50 p.m. to 9:50 a.m., was there any dew on the ground?
No, the dew point never got within 6 degrees of the temperature never got within 6 degrees of the dew point, which is the point at which you would see condensation or dew moisture.
And sir, is there a column in the official Weather Service reports to indicate the presence of any obstruction, any visual obstruction, such as fog or haze?
Yes.
And do the reports indicate whether there was any ground fog at all that would obstruct one's view from 10:50 in the evening on June 12th to 9:50 in the morning on June 13th?
Objection, that's irrelevant beyond the scope of the expertise.
Sustained.
Do the reports indicate, sir, what the visibility level was for
Yes.
each hour from 10:50 in the evening till 9:50 the following morning?
Objection, Your Honor, regularly on.
Sustained. It's not relevant to LAX.
Professor McDonald, are you aware of the fact that the only official Weather Service readings throughout the entire night for the Los Angeles vicinity are those at LAX?
No, I wasn't aware of that. I wouldn't be aware of it in New York.
Is there any indication at all in those official Weather Service reports that there was any fog that could create any moisture on the ground on the night of June 12th and the morning hours of June 13th?
Sustained. I think we have the basics, though. We have temperature and humidity, so let's move on.
Okay. Now, did you visually examine the glove that was collected at Rockingham?
Yes.
And did you have an opportunity to see the places where there is dried blood on the palm side of the glove and the back side of the glove?
Well, there's stains which has been testified to as being blood. I did not test them, but there's certainly staining consistent with what blood stains look like.
And sir, I now show you what is People's Exhibit 68D.
Objection, beyond the scope of
Oh, well.
Professor McDonald, this is a picture that was taken by the police of the glove at Rockingham, a close-up, in the area where it was collected. You see that picture?
Xerox copy on it, just so the record's clear.
Fine. Xerox copy.
No, it's not. Is this a
It's a,
Xerox?
it's a
copy?
photo Xerox because the original photograph
Right.
is mounted on a board that's in the basement, Your Honor.
Thank you. Proceed.
And sir, based on your expertise in the area of blood stains and blood stain analysis, if this glove had been dropped at that location within 10 or 15 minutes after the wet blood was smeared on it, would you expect to see blood on the leaves or on the pavement that the glove is resting on?
Objection, speculation.
Sustained. Sustained.
Sir, did you actually see the location of the blood stains on the glove that was found at Rockingham?
Yes, I did.
And from looking at this photograph, would those areas that had bloodstains be in contact with the pavement and leaves directly beneath it?
Objection, no personal knowledge, no foundation.
Sustained. We're here talking about shrinkage, counsel. That's a scope issue.
Sir, are you aware of the fact that the criminalist in this case did not offer any testimony of seeing bloodstains either on pavement?
Sustained, counsel. The scope is shrinkage. Move on.
Now, you said that there came a time when the gloves were dried that you did this experiment on. Is that right?
That's correct.
And after they were dry, what did you then do with the two gloves?
I copied them on the copy machine that I'd used before when I copied them prior to the experiment. Same copy machine.
And did you then compare the Xerox copy of the gloves taken before you did the experiment with the transparency Xerox of the gloves after they had dried, having had all this blood smeared on them?
Yes, I did.
And what, if any, shrinkage did you observe as a result of your experiment on both the left glove and the right glove?
I would have to say it's negligible. They're certainly not congruent because they were done at different times, but I put them down as fairly as possible. That is to say, without any lateral teasing around to stretch them one way or another. Just laid them flat, did the experiment. When they're dry, laid them flat again. And they are not congruent. That is, they're not the same copy. But when you place one over the other and move it around slightly, I can detect no shrinkage or no linear or vertical or horizontal shrinkage at all, or change, shift.
And sir, do you have the Xeroxes and the transparencies that you made when you conducted this experiment with you today?
Yes, I do.
Could you take them out, sir? Let's start with the left glove first, if you have that handy, or the right glove, whichever is easiest for you.
All right, you given a copy of these to counsel?
Yes. Which glove do you have out?
I don't have either glove, but I've got a transparent copy of one, of the left glove.
Okay, let's start with the left glove. Now, I have to mark these for identification.
Your Honor, we've never seen these, yeah?
Your Honor, that's not true. They were given to people in Discovery.
No, we got Xeroxes.
All right, let us see the originals.
These are Xerox.
That's a Xerox.
No, the transparency is held by Mr. McDonald. We've
All
never
right,
seen
let
them.
counsel see the
You did
transparency.
receive that as a Xerox as well, Your Honor.
Let her see the original, please.
Certainly.
Thank you.
Can you use the other hand as well? Sure. But just give me those back first, because I don't want to set the left hand and right.
Your Honor, can we approach?
Without the court report.
Yeah, bring in.
All right, thank you, counsel. Don't mix those up, Mr. Newfeld. I know, I noticed this. Mr. Newfeld.
Fine. Let's begin with the left hand. You have in front of you three different items, and I guess next in order is,
This would be 1379, and they'll be,
let's make this 1379 A, B, and C, and then we'll make the other hand 1380. That's all right. Okay.
sounds good to me.
Professor McDonald, could you please explain to the jury what 1379 A, B, and C are?
You want to mark them A, B, and C, make the red, which one do you want as the,
A will be the four-shot, the pre-drying, the pre-shrinkage experiment, Xerox of the glove. The brown transparency can be, after the gloves are dried, will be B.
No, that's not after, that's before. There are two before and one after, for clarification.
All right, well, okay. You mean there's one transparency and one on white that's before?
Shall I explain this?
Please do.
The one on paper is before. LB stands for left glove before experiment. I then made a left glove before transparency because I felt by having left after in red was perhaps not easy to hold up to a light, so I thought I'd make it what I call jury friendly and have them both transparencies, that's all. So my label 1 is before the experiment, my label upper left 2 is the same thing, it's the same identical picture. And then 3 is after in red. And you can compare 3 to 1 or 2, whichever seems to be the easiest for your eyesight.
Then with the court's permission, perhaps what would be easiest is not to introduce at all the one on white paper and simply introduce the two transparencies. The brown one will be a transparency of the condition of the glove prior to the shrinkage experiment, and the red transparency will reflect the condition of the glove after the shrinkage experiment.
Not wanting to tell you how to try your case, though, but my personal...
I'm willing to defer. Go
My
ahead.
personal examination of the one on the paper with the red is that it's easier to make the overlay comparison, but you're the lawyer.
All right. At this point, I really, move this along, we'll do it that way then. And we'll simply introduce the one on the paper then will be A, and the red overlay will be B, and we will not introduce the other transparency.
Fine.
Okay? And so, Professor McDonald, did you do the same thing for the right glove?
Yes, I did.
And could you please show the ladies and gentlemen of the jury what it appears to be? Both the before photocopy and the post-shrinkage experiment transparency.
Yes, in this instance, my number 7 is the right glove before, which is on paper. It's not a transparency. The red transparency is the right glove after. And again, they're not congruent because they're not exactly the same. They were done hours and hours apart.
But was the one in red done only after the gloves were dry?
Yes, and it says RA, that's right after, and the other one says RB, that's right before.
Your Honor, at this time, I would like to, and by the way, I think the second set should be marked Defendants 1380, A and B, with A being, unfortunately, A is going to be before and B is after. And at this time, with the court's permission, I would like to be able to pass them around to the jury.
Yes, would you hand the left glove to juror number 1 and the right glove to juror number 7? You collect those items 1379, 1380 from Deputy Bashmakian, please. All right, the record should reflect that each of the jurors has had the opportunity to view both 1379 and 1380. Mr. Neufeld.
Yes. And remember when I asked you at the very beginning of your testimony, Professor, whether or not you recall Mr. Rubin's testimony that the evidence gloves that he examined were 15% smaller than the new Aris Light Extra Large gloves. Do you recall that?
Ma-
You're,
Oh,
it's 15%.
15 is what I read.
15, page.
My recollection was 10 to 15, and on that basis, I prepared a way to show both 10 and 15%, or 85 or 90% of the original.
Okay. Did you prepare transparencies which reflect these gloves if they were 10% smaller and 15% smaller than they are in their new condition?
Yes.
And how did you do that, sir?
I prepared yet another master of the left glove by putting a ruler next to it and then using a variable enlarging, reducing copier, not my own. I do not have one of that nature yet. I'm expecting one shortly. I set it at 90% and simply made, again, a red transparency that I could first check the ruler, which is quite faint, and see that it is exactly 90%. In other words, 100 centimeters on the smaller one only is 100 millimeters is only 90 millimeters on the original. And so it is right exactly 90% as I read it. And that was just to show the reduction by placing the red transparency over the original to see how much smaller it would be. And that is the figure I would give to the evidence gloves because I've examined them. The gloves on my pictures are 10 inches, the actual gloves I have, and 90% of that is 9 inches, and the evidence gloves are 9 inches. So I think it's 90% and not 85. But I also prepared the 85, which is, of course, a 15% reduction. And I would say simply that it goes from a man's size to a lady's size. It's very much smaller. But either way, it's an incredible shrinkage.
Okay. Can you, is it possible the way you have done the transparencies on the photocopying machine, is it possible for the jurors to actually compare what the Aris Light Extra Large glove looked like before it was, had blood put on it in this case, in your experiment, and what gloves that are 10% smaller would look like and what gloves that are 15% smaller would look like?
Yes, I'm sure they can. They just did it before. I watched them.
All right.
So this is 90%. This is 85.
Your Honor, I would ask that the two reduced versions, the 10% and 15%, be marked 1381 A and B. And is that for the left hand that you have first?
Yes.
Your Honor, I think for the purposes of this experiment, one hand should be adequate. So we'll do it just for the left hand. And I would ask Your Honor at this time to be able to pass that around to the jurors as well.
Have you shown those to Ms. Clark?
Oh, sorry. What's permission? Which juror? One?
Juror number 1.
Okay. You have a sidebar while they're doing this?
right, Deputy Vashmikin, would you hand that back to Professor McDonald? Excuse me. Yeah. And Professor, may I see that, please? Thank you.
Can I continue?
2 seconds.
Okay.
Professor. Thank you. Mr. Schnufeld.
Thank you. Professor McDonald, in your expert opinion, and based on the experiments that you conducted, could the Rockingham glove and the Bundy glove be smeared with, I'm sorry, could the smearing of the Bundy glove and the Rockingham glove with blood on the evening of June 12, 1994, account for a 10 to 15% shrinkage in those gloves?
Overruled.
I can't imagine it's at all possible, no.
Now, let me ask you one other question, not involving these gloves, sir. Did you hear FBI agent Bodziak's testimony this morning and yesterday regarding the color changes that bloody shoe print stains will undergo during the course of time?
Yes, I did.
And did you hear his testimony in which he said that whereas a glob of blood will turn from red to black or dark brown to black, a light blood stain will not go through that color transformation, but instead will simply fade and get lighter and lighter? Do you recall that testimony?
Yes, I do.
Is Agent Bodziak right scientifically, sir, when he says that?
Scientifically, I wouldn't say so. Maybe that's what he observed. I don't know what he had his thin blood prints on, but that has not been my experience, and I have them back in the 60s that are thin blood prints, and they're still dark. They didn't fade.
Could you please explain very briefly to the ladies and gentlemen of the jury what is the biochemical process that occurs that causes bloody prints, be they globs of blood or light bloody prints, to go from red to dark brown to black?
Well, the color portion of blood, the red portion, is hemoglobin, and as it oxidizes, it gets darker. And it doesn't matter whether it's a thin film or a thick film, it will get darker. I do not know of an instance where it has disappeared, except in some of my cardboard, the silverfish have eaten it away, but just chemically, it doesn't disappear.
Thank you very much. No further questions.
All right, ladies and gentlemen, we're going to take a brief recess at this time just to change exhibits, and I'm going to ask you to step back in the jury room. We'll take about 10 minutes. 15? 10 minutes? All right, we'll take about 10 minutes. All right? All right, let the record reflect that we've been rejoined by all our jury panel members, that Professor Herbert McDonald is on the witness stand undergoing cross-examination by Ms. Clark. Ms. Clark.
Thank you, Your Honor. Good afternoon. Good afternoon, Mr. McDonald.
Afternoon.
Now, the gloves that you performed your experiment on were brand-new gloves, is that right?
Yes, the
Okay.
gloves that I received.
As a matter of fact, showing you, sir, 1378C. No, I'm not. Yes, I am. There's a tag on that glove?
Yes, there is.
That's a tag that would be like on a brand-new glove, is that right?
Yes, that's the way I kept the right and the left separated without having to open envelopes. This is the right glove.
And when you got the glove, was it still in its plastic packaging, sir?
I believe it was, yes.
Now, the crime scene gloves that you examined were clearly not new gloves. Isn't that right, sir?
Oh, that's true. They were well worn.
And the gloves that you tested, being brand new, were never rained on, correct?
Not that I know of, no. They could
were
have
in
been
their-
repackaged. I'm not sure it was the original package. I've had them in and out of plastic protecting plastic bags, so I don't honestly know if it was a brand new package I got them in when I received them, but they were wrapped up.
Okay, and they appeared to be brand new to you, didn't they,
They
sir?
were definitely brand new.
Okay, so they'd never been, as far as you could tell, they had never been rained on,
No. I couldn't
snowed
see
on,
that. No,
sleeted on.
no.
All right. They appear to you to be pretty pristine. Would that be a fair statement, sir?
Very much so, yes.
Now, you picked a certain amount of blood to pour on the gloves to do your experiment. Can you tell us why you picked that particular amount?
That's what a vacutainer contains. I felt it would be adequate, and I was giving the blood.
Okay. It was your blood?
Yes, I didn't need 25 milliliters, I didn't think.
All right. Do you know, sir, precisely how much blood was on the Bundy and Rockingham gloves?
No, I do not.
Okay. So this was just kind of a random selection of an amount of blood to put on there.
No, it was what I felt would be an adequate volume to smear all over a surface. And as it was, it only took 2 out of the 9 milliliters, so it was certainly more than adequate.
All right. Now, you smeared it on with your latex glove, correct?
That's correct.
You don't have any reason to believe that blood was smeared in that fashion on the Rockingham or Bundy gloves, do you, sir?
No, I'm sure it was not.
Now, do you hold yourself out to be an expert in glove manufacturing
Certainly not.
or in the process of leather treatment, leather of the type being used to make gloves?
Well, I've tanned quite a few hides when I used to hunt as a child and boy, but not to make gloves, no.
Okay. And you heard, did you hear Mr. Rubin's testimony concerning the preparation of the treatment of glove leather for the purpose of making it less water permeable?
Yes, I recall that. I think it was referred to as naked leather.
Yes. Do you recall his testimony concerning the treatment of leather for gloves with by immersing them in chromium, formaldehyde, and certain oils to prevent rot?
No, but it sounds like a good procedure. I'm not familiar with it.
Are you familiar with the use of fat liquors and oils that are added to reduce the potential of shrinkage when the gloves get wet?
No, not at all.
Do you have experience, sir, in the weathering of gloves that strip the fat liquor and those treatments to prevent shrinkage?
No.
Objection comes back on evidence as to these gloves as opposed to other types of gloves.
Oh,
And do you have personal knowledge and experience as an expert, sir, in the manner in which stretchability will be affected by the weathering of gloves in which the fat liquor is stripped by being subjected to weather such as rain, sleet, or snow?
No.
There's no testimony on that.
well,
And do you have any expertise or knowledge, sir, in the properties, the resistance that a glove will have? Strike that, let me start again. Do you have any expertise or knowledge, sir, in the decreasing ability of weathered gloves to resist shrinkage due to the strippage of the fat, liquor, and other treatment processes?
Objection since facts not in evidence.
Oh.
Well, the first part I understand, but the last part I don't. Could
Let me see
you
if-
break it into two questions, perhaps?
I'm going to try. Okay. Is it part of your fund of knowledge, experience, and expertise as a forensic scientist, sir, that strike that. Do you have experience and knowledge and expertise in leather gloves and the properties of their ability to resist shrinkage after having been subjected to various weather conditions?
Not in their ability to do it. I observe it, but I don't know what it is that causes leather. I don't know if it's to shrink or to return to its original size. Mm-hmm. My experience with rawhide and leather is that if you wet it, you can stretch it, mm-hmm. and then it will shrink back to the original size. So that is not shrinkage. That's mm-hmm. just returning to status quo. That's why I wondered about your previous question. I'm still not sure, but I'm not an expert on glove shrinkage.
Okay. And I think what I'm getting at, sir, is this. As a glove ages, the treatment that had been initially put on it, do you have expertise in the field to know whether that treatment will wear off to the point where it will resist shrinkage less when subjected to wetness or water?
No, I don't have. Certainly, if there's a treatment that's put on anything to prevent something, as the chemical, whatever it may be, is worn away or leached away for whatever reason, then the purpose it was put in there is going to be less achieved than it was when it was fresh, if that comes close to the answer to your question.
Okay, yeah. And that seems clear as a matter of common sense, doesn't it, sir?
Yes, exactly.
Without even being a glove expert.
Certainly.
Now, you do not know the history of the gloves that were found at Bundy and Rockingham. Would that be a fair statement, sir?
That is.
And the only pair of gloves that you tested were the brand new pair of gloves that were given to you as provided by Richard Rubin, the glove manufacturer expert.
Yes, that's correct. They were not given to me directly by him, but indirectly.
And your knowledge is that they came from him. Is that right, sir?
That's correct. That's my belief.
Now, do you know anything in particular about the properties of these Eris-like gloves?
I never heard of them before, this case.
And can you name for us specifically any prior case in which you've come in to testify to a jury concerning the shrinkage of gloves due to the application of blood?
No, counting this one once.
Okay. And are you aware, not being a glove expert by your own admission, sir, are you aware of the variation in range of sizes of extra large? In other words, that there is variation in the size of extra larges.
Well, I don't know about extra large, but when I buy large, some of them fit, some don't. And they both say large, so I'm sure there is a difference in extra large as well. They're not all the same.
Now, do you have any gloves, sir, that are handmade?
I think I do.
Do you have any gloves that retail for $77?
A gross?
No, retail price.
A pair?
A pair.
No. I'm Scottish. No.
Right. Are you?
Work gloves is about what I buy.
I'm sorry?
Work gloves for stacking wood. That's the most leather gloves I have.
Are you aware, sir, that that there is testimony to the effect that this type of glove retailed back in 1990 for $77?
Excuse me, counsel, I think we're, remember there was a discount, there was a
Yes.
manufacturer's, and these were two pairs, wasn't it, for 77?
Oh, I'm sorry. Thank you.
Fifth manufacturer's retail price was what, 50?
55? 55.
Never buy retail.
That's right. Okay. Let me amend that statement, sir. Do you have any gloves that cost $55?
I hope not. I don't know. My wife frequently buys gloves for Christmas, and I hope she doesn't spend that much.
Does that impress you as a pretty expensive glove?
I would say it's got to be a very nice glove, and these are nice gloves. I'm not questioning the retail price of them or the sale price, but I would not ordinarily expect to have a pair like that myself.
Now, you, of course, did not measure the Rockingham and Bundy gloves before the murders, correct?
No,
And you don't know what the condition of those gloves was with respect to the fat liquor and all of the chemicals applied to resist shrinkage prior to the murders, correct?
Chemicals applied to reduce shrinkage. Seems facts not in evidence.
only to the extent that because of the wear, whatever was there originally wasn't there in the same amount that it was to begin with.
You
Because if
examined
they
them?
were worn, certainly things were missing.
So then you would agree, sir, that prior to the murders, as worn as they appeared, there was some lesser degree of protection from shrinkage on those gloves.
Objection, since that's not in evidence.
I don't know. I would assume so, but I really don't know. If a worn glove loses its ability to resist penetration by moisture or whatever it is that could cause shrinkage over a period of time, then yes, but I really don't know. It would be logical, so I'll say conditionally, it seems that it would be less likely to resist shrinkage or anything else, staining, whatever, if the chemicals that are put in to prevent that are no longer in the same concentration.
Which is a likely thing to occur over a period of time and to be found in worn gloves such as these, correct?
It would seem so, yes.
Now, you did not measure the gloves in their original size just before the murders occurred, did you, sir?
No, I think I've already said that.
Nevertheless, and you're aware that these are extra large gloves, the Rockingham and Bundy gloves.
They are so stated, yes.
Then presumably whoever wore them fit the size extra large. That would be a fair common sense
That's common
inference,
sense,
correct?
Objection, Your Honor.
Oh, the actual stand. Next question.
Now, you do not know what conditions those crime scene gloves were subjected to before the murders, correct?
That's correct.
And you don't know precisely what conditions they were subjected to after the murders, is that correct?
Are you referring to immediately after the crime and before they're collected, or from the collection point on?
Well,
Yes. Before they're collected, I have no idea. From collection on, I assume they would be preserved in some forensic manner that would not further alter them.
okay, then you don't have any personal knowledge of either aspect of how the crime scene gloves were treated after the murder.
That is correct.
All right. Then you are not aware of the fact that the crime scene gloves were frozen and unfrozen a number of times.
I had heard that they were, yes.
And you do not know precisely how much blood was actually on them, is that true?
That's correct.
You said you measured the crime scene gloves, sir?
Yes, I did.
And you said they were 9 inches?
Approximately 9 inches in length.
And the gloves, the brand new ones that you had, were 10 inches in length?
Yes.
Then you found that there was indeed a 10% difference between them, correct?
That's correct, yes.
Now, you testified to temperature and humidity based on reports taken that were generated from Los Angeles International Airport?
Yes, I did.
And
do you have much more?
Not much. Not much.
Mr. Neufeld, how much more do you have left?
Oh, a minute.
Hurry,
Want to try?
let's try.
Okay. Okay, You attempted to duplicate the weather conditions stated for the Los Angeles International Airport for the night of June the 12th, correct?
Yes.
You did not.
Check in the morning, June 13th.
Okay, June 13th. Showing you People's 60, sir. People's 44. Showing you that photograph, sir. You did not place your glove, the experiment glove, on soil, did you?
No.
You did not place it underneath a plant, did you?
No.
And showing you People's 169? People 69? You didn't put your experiment glove on pavement on the pavement that had leaves on it, did you, sir?
No, I did not.
And you didn't put it on a pavement that had leaves on it with overhanging trees, did you, sir?
No. Well, actually, there were overhanging trees, but they were over the roof. So they were under overhanging trees. The laboratory's in the woods.
They weren't hanging over the glove, though, were they, sir? Well,
Not without the roof in between, no.
all right, sir, are you aware that the first time the crime scene gloves were ever measured was after they had been frozen on June the 21st, 1994? Were you aware of that?
No, I didn't know when they were measured.
Now, sir, you testified concerning bloody shoe prints. Let me just ask you a couple questions about that, if I might. So you're not testifying that shoe prints never fade, are you?
No, there can be reasons that they will fade, I'm sure.
Okay. And would you expect to find shoe prints that were not visible at the time of the murder to suddenly become visible in detail 2 weeks later?
In blood, you're referring?
Yes.
Not without some enhancement procedure. I wouldn't think they would just appear suddenly. They might be more noticeable, but if you're talking about stark contrast, I couldn't see how they would just suddenly appear very dark.
Okay. And let me ask you something else, sir. If after photographs are taken of a crime scene to depict all of the bloody shoe prints at a crime scene, and people walk through the crime scene after that, and that is after it's broken down, and subsequently pictures are taken,
Actually, beyond the scope. He just talked about a biochemical reaction.
and subsequently pictures are taken that show the appearance of shoe prints that were not shown in the photographs before the crime scene was broken down, will those shoe prints have any significance to you as a forensic
Objection
scientist
assumes that's not in evidence. Move to strike.
in the solution of the murder, sir?
I don't think I should generalize on that. I would certainly want to study it in as much detail as possible, but simply stated, shoe prints, heel prints do not appear unless somebody's been there.
Right. On a common sense basis, sir, if you see a somewhat faint shoe print in a bloody crime scene, would you expect to see a similar shoe print somewhere nearby?
Sustain. Sustain.
Okay, and the new gloves that you tested that were given to you initially by Richard Rubin, those were the only gloves that you tested in this case, correct?
That's correct.
And with your experiment, sir, you cannot tell us why the crime scene gloves are 10% smaller than your brand new gloves. Isn't that correct?
If they're the same size, they shrunk, yes. But other than that, no, I don't know what caused it.
Thank you very much, sir.
Mr. Neufeld.
But you did give your opinion that whatever caused it, it wasn't the amount of blood that was smeared on it on the night of June 12th. Isn't that correct, sir?
No, if I'd have used 10 times as much blood, I could get 10 times as much shrinking, which is 10 times nothing is still nothing.
Thank
So
you.
I wouldn't use any more.
Right. And, sir, remember when Ms. Clark asked you some questions about shrinkage and new gloves versus old gloves. Do you recall Mr. Rubin's testimony that these gloves were made with something known as naked leather?
Yes,
And are you aware of the fact, sir, that these gloves did not have any Scotch Guard or other type of water repellent chemical sprayed onto it?
that's correct.
That's it. And applied
Stay.
to it.
I mean, overruled. There's nothing, no testimony about spray treatment. Proceed.
And sir, are you aware of the fact that between June 21st, 1994 and June of 1995, a year later, that these gloves were frozen and thawed many times in the crime laboratory?
I think I've been told that. I would not be surprised if they keep them in a freezer to examine them. They have to take them out.
And are you aware of the fact that notwithstanding that they were frozen and thawed and frozen and thawed and frozen and thawed repeatedly over that 12-month period of time, when the gloves were measured in June of this year, they were not any smaller than they were in June 21st of 1994? Were you aware of that? Oh, that's
Sustain. Sustain.
Did you have an opportunity to see a diagram that was made by Susan Brockbank of the gloves in question in this case at some point during your investigation of this matter?
I may have. I do not honestly remember it.
Do you recall that the measurements that Susan Brockbank testified to regarding the gloves in June of 1995 were not at all different, were not at all more than 1% different in 1995 than they were in 1994?
Yes,
That's,
Overruled.
I do remember that. I believe I saw that particular testimony.
and finally, sir, Ms. Clark asked you a series of questions about whether you could replicate every condition that these gloves were in when they were recovered on the morning of June 13th. And she showed you a picture before, or asked you about, when you did your experiment, did you put the glove in soil? Remember her asking you that?
Yes,
Well, would soil make the gloves any wetter than the blood did?
Sustain. Sustain.
Given the fact that there is no testimony at all in this case about any precipitation or any wetness at the Bundy location, would putting the glove under a plant or a plant leaf make any difference in the amount of wetness that those gloves had as a result of being soaked with blood?
United States testimony.
Overruled. Overruled.
I cannot imagine how it would. No.
And sir, she also showed you the photograph of the way the glove appeared at Rockingham when it was collected on the morning of June 13th. Did you see that photograph?
Yes,
Do you see anywhere in that photograph leaves glistening to indicate that there's any moisture at all in those leaves?
Your Honor.
Sustain.
Would the fact that there is no moisture on those leaves or on that pavement do anything?
Assumes facts not evident in evidence, counsel. We've already talked about the dew point, we've talked about the humidity, we've talked about these other factors. That you're
Would the
either way,
fact,
these things.
okay, would the fact that the glove in your experiment is not on pavement, but is in that glass contraption that you created, would that make any difference, sir, any appreciable difference in the results that you generated?
I didn't create it. I got it from the research laboratory. No, I don't think that it would.
Thank you very much.
One question. Sir, you testified that you were aware of the gloves, the photographs of the defendant in the gloves at the football games that were shown to the witnesses earlier or last week?
Beyond the scope of redirect, Your Honor.
Overruled. With some latitude, where are we going on this?
I have seen the
One
picture.
question.
Pardon?
I have seen the pictures.
Did you test those gloves, sir?
Objection, Your Honor. Your Honor, she already asked him whether he tested any other gloves.
Sustain. He indicated no. All right, Professor, thank you very much, sir. You're excused. All right, ladies and gentlemen, we're going to take our recess for the afternoon as far as the jury is concerned. Please remember all my admonitions to you. Don't discuss the case amongst yourselves, form any opinions about the case. Don't allow anybody to communicate with you. And what did I forget? I'm sure I forgot something. In any event, have a pleasant evening, except for those of you going to the dentist, and we'll see you all tomorrow morning, 9 o'clock. All right. The jury is not present. All right, earlier today, Mr. Cochran, you gave the court a list of witnesses that you anticipated upcoming. Where are we?
Well, I did give you a list, and I ask Your Honor, in the interest of trying to move this case along, to assist us with certain of the witnesses. Certainly, Sherry Ray was in fact here, and I think I spoke with Your Honor before the break, and I excused her. She'll be back tomorrow morning at 9 o'clock. We do need Detective Van Adder. We do need Mr. Martz from the FBI.
All right, this is for testimony in front of the jury.
Yes, yes. We have further cross-examination of each of those parties, and that'll be still, I believe, in our case in chief. We expect to call, excuse me, Your Honor. Excuse me.
I just passed it along.
I got a note that threw me off momentarily. We're going to need to, at some point after we deal with Detectives Van Adder and Agent Martz, we wanted to have the Fiata brothers, and I understand that my office has issued subpoenas for them today, an FBI agent named Michael Wax, W-A-C-H-S, Deputy District Attorney Dale Davidson. All those witnesses relate to the same thing, statements allegedly made by Detective Van Adder. May not need all of them, but after Van Adder testifies, we may need some of them. And what I guess I'm indicating to the court is I think we can pretty much wrap up the balance of our case and the rebuttal, if not tomorrow, certainly by Wednesday morning. And then there's the issue of Agent Whitehurst. And we think that I don't know when you plan to read the various and sundry items, but we feel very strongly that there are specific links to this case involving Mr. Simpson. There are some.
Well, I'm not reading anything until somebody submits an offer as to.
Well, we had agreed, and Ms. Clark and I had agreed, and basically we want to start with Martz at any rate. So a lot of it depends on what how he responds. But we had agreed, Ms. Clark and I had agreed, I think, that we weren't going to make a proffer in writing necessarily because of the time. We wanted to move the case along. But if you think you want that, we can do it. We'll make it easier for Your Honor. We'll do that.
Well, here's the problem. You're going to make a proffer. You're going to ask me to read things and review transcripts and that sort of thing. So,
well, I think what we want to do is make some representations to you, and we will ask you to read certain things. We got more documents today from Washington.
Okay.
So you tell us what's most feasible, that will save you the most time, so we can get this matter over into this jury as soon as possible.
well, I see. Here's the problem. I hear the name Whitehurst bandied about. I don't know what's going on, and I frankly try to avoid the news media reports on all of these things.
I understand.
And I have been successful, at least as far as Mr. Whitehurst is concerned. So, what are we dealing with here?
Well, let me have Mr. Blazer address that. He'll be dealing with that witness on Agent Martz.
Yes, Your Honor, there's a lot of material that we've been accumulating just in the last couple of days.
If we're going to talk about this, can I get Mr. Kilberg here because, or at least Mr. Hodgman, I was not present during these interviews.
Well, what we're about, okay. Yes, I think we need to do that since we're talking about a proffer here, and I sense a 402 coming.
Well, what I would suggest is, and we talked about this before, and I think we talked about it with Your Honor, that we would make a verbal presentation as to what we think is relevant, what we would like to call Agent Whitehurst for, then they could respond, and then if we felt, either side felt that you needed to read any of these materials, then we could direct your attention to whatever you need to read. There's no way you're going to read all of this, and I don't think you need to, quite frankly.
Okay. Mr. Kilberg?
Well, Your Honor, I have to confess I've heard very little, and I was not...
All right, Mr. Blazer, why don't you repeat your last 60 seconds worth of comments from Mr. Kilberg?
My suggestion is that we both make an oral or verbal presentation as to what our offer is, and then if either side feels the need to have the court review any specific materials relating to what it is we're talking about, then we can direct the court's attention to that at the time.
In general, I don't have a problem with that. I think, number one, though, the court should be aware. I talked to Mr. Eglash, who is an assistant U.S. attorney who was one of the lawyers present during the interview with Dr. Whitehurst. Apparently tomorrow, he anticipates receiving through overnight delivery a large number of documents. Apparently the defense has subpoenaed with at least one, if not two additional subpoenas today, certain records out of DC. The records are going to be provided, as I understand, to Mr. Eglash for tomorrow. I suggested that Mr. Eglash come here at 8:30 tomorrow so that we could represent to the court what he represented to me, which is he won't have the documents till about 10:30, and he believes the documents will be divided into three categories. One, which is the documents they're willing to turn over to both sides as is. Two, I believe, is a series of documents which they would ask the court to review in camera to see whether or not they are relevant, and if the court deems them relevant, to turn over to both sides in the redacted fashion suggested by the agency. And three, a series of documents which they believe under no circumstances should be turned over for reasons that Mr. Eglash would much better express than I. Now that I've made this representation to the court, we might save time as to when Mr. Eglash should be here tomorrow, if that becomes necessary for the court's consideration.
Well, here's the problem. If he's not going to have the documents until 10 o'clock in the morning, then obviously we won't get to it.
And he indicated to me it's going to take them some time just to sort them into the appropriate package and have whatever paperwork they feel is necessary. He was hoping for a 1:30 appearance here with whatever materials he has been provided from Washington.
I don't have any problem with that. That may mean that if we're going to call witnesses, it might be Wednesday morning.
That's fine. Number one, has the court read any of the materials on Dr. Whitehurst which were submitted, I believe, on Friday, the 26-page memo, and there may have been other things?
No, I have not read anything yet. I have the original memo, I have a transcript excerpt, and I think there's one other item I might have in my package, I'm not sure.
Because I would ask, I think the court should read the 26-page memo. I don't think the court can get a flavor of Dr. Whitehurst without reading that memo, irrespective of what additional things either side may feel is necessary for the court to read in assessing what relevancy, if any, Dr. Whitehurst has to these proceedings.
All right, then I'll take that home if you don't object, Mr. Blazier, and read both items this evening.
Only with the understanding that we have a number of documents that relate directly to the Simpson case, which we think you should also review. I don't know if we may be able to make copies for those. You can take those with you too.
I have no problem as long as I'm apprised which documents they are. I don't know if the defense is aware. I've been upstairs, so I have been receiving documents, copies of which I have been told have simultaneously been provided to the defense, not necessarily in the same mechanism, because I believe the defense has a lawyer back in Washington, D.C. who may be getting physical possession immediately. Ours is through faxes from the United States Attorney here, or from a representative of the Department of Justice who is out from Washington and is receiving them, I believe, in an office in Westwood. Long and short is there are a number of letters that Dr. Whitehurst sent to the Inspector General's office. Much of the material has been redacted, just blacked out, but there are references in these letters to Simpson and Marks and so forth. If those are the letters, I don't know if you have them yet, I have no problem with the court reading those. We received some letters, I think also from the FBI today. I have not had a chance to review those in detail. I have no problem with the court reading those. And if the court gets the second transcript, yesterday's transcript, what I'm going to ask the court to do is read. I was the last lawyer to question. So my questioning, primarily, I had the opportunity to ask for clarification during the course of the examination by other lawyers, primarily Mr. Blazier and Mr. Neufeld. But my questioning is the last question, about the last 40 minutes. I'd ask the court to read that 40-minute segment of questions. I don't know how many pages it is, because that summarizes what I think the court needs to know about Dr. Whitehurst and his relevancy to these proceedings.
Well, let me get a running start with the items that Mr. Blazier suggests this evening. Believe it or not, I actually have other things to do with my life every year.
I'm shocked to hear that, Your Honor.
Yes, all right. My koi pond pump died on me this morning, so
Hopefully not the koi along with the
if
pump.
I don't get a new pump, I'm in trouble.
I think you'll probably have one within an hour and a half.
No, it's a very special pump, believe me.
Your Honor, just when do you want us here?
Well, Who are our next witnesses, Mr. Cochran? Let's assume that we won't get to the Whitehurst issue until tomorrow afternoon.
I would expect that. I think we're going to have hopefully Ms. Ray, Secretary Van Adder. I'm trying to have Mr. Douglas check to see if Agent Martz will be out here. Those will be our next witnesses, it seems, and before we get to Whitehurst. And then the Fiata brothers, I understand they're here. The FBI agent Wax, Dale Davidson, DA. We'd have enough witnesses in the morning to take care of, and then we can get to Whitehurst at the end.
Okay.
Your Honor, lest we be considered to have waived anything, I'm here to get a specific offer of proof, excuse me, Mr. Cochran, from the defense with regard to Officer Sherry Ray, who we received discovery for just this morning, and who I have had an opportunity to interview. And we have some vigorous objections to her testifying. So I don't want it to be assumed that because the defense wants to put her on, that the court is going to allow it.
All right, when do you want to do that?
I'd like to get a specific offer of proof from Mr. Cochran as to exactly what they would assume that Officer Ray is going to testify to, because the notes with which we were provided have a lot of buzzwords and inflammatory phrases that turned out not to be something that this witness could or would say that Mark Furman ever said or did. So I would like to start with an offer of proof from the defense as what they wish to call her for.
Mr. Cochran, I take it she's your next witness up?
Yes, she would be here.
All right, what's your offer of proof regarding this witness?
Certainly, Your Honor. May I say one other witness that we potentially will want is mentioned this morning, Gary Sims also. And the reason I keep mentioning these witnesses, Judge, because if we don't get it, they're not here. We need to get some effort to get them here as soon as possible. Now, in responding to Your Honor's question, LAPD Officer Sherry Ray, as an offer of proof, we will proffer the following: that she was employed by the Los Angeles Police Department between the dates of January of 1982 and I think 1993. She's off on, I think, some kind of stress disability leave presently. She was worked with and was a partner with on various occasions from September 1985 through about December 1988 with Detective Mark Furman. She is the first and only police officer we expect to call in this regard. She worked with him in West Los Angeles Station, and she has heard him.
She was his partner officer?
She was a partner on occasions, but she also worked. His partner most of the time was Tom Vitriano. She would work in another car and provide backup for those in the SPEW unit. And she has worked with him on occasion, but she was not his regular partner. But she knows him very well. She knows and has information regarding his use of the N-word repeatedly during this period of time. She has information regarding what she calls a code, a conspiracy of silence among the officers in protecting and covering for one another. She specifically uses a term, and I'm quoting, so there'll be no mistake about that. It's time to pencil fuck a nigger, which has to do with writing reports in a misleading way where they lie and change facts around to justify probable cause or to implicate someone who's otherwise innocent. She knows and can testify, as I said, about this major code of silence and something the officers routinely call test-a-lying, that they use the term test-a-lying. And then finally, that in 1988, her last day in that particular division, she worked with this particular officer, Furman, who a couple of days before that, she and he had won some kind of accommodation for an arrest, a grand theft arrest. And he pulled into the station at 5:00 a.m. on this date in December of 1988. Said, I've been authorized to tell you what all the male officers out here think about you. He then launches into a tirade where she feels very, very frightened and intimidated and gets out of the car, leaves her in the car and goes in the station. And there's 2 more hours left on watch. But she understands him. In addition to that, when she heard him testify in February and said he'd never used the N-word in 10 years, she knew he was lying then. But I asked her, why didn't she come forward? She said, because it would do no good. Internal Affairs would investigate it and they do nothing about it. That in fact, she did in fact report it later on, and they said, we'll get back to you. And she gave me the name of the officer, Manini, I believe it is, at IA, so they never even bothered calling her back. So she is off on some kind of stress disability leave now, but she was here today with lawyers and also with her defense rep. I think, Judge, that with regard to her and anticipate any arguments of cumulative, this is a lady specifically, and you'll recall that we had the two ladies, we had Singer and we had Kathleen Bell, and you said we could bring forward. We then had McKinney because of the tapes. We had Roderick Hodge, who was a suspect who dealt with the affront of Furman, and this is an officer who worked with him on occasion, backed him up, dealt with him specifically, and knows about the milieu of that particular division and the LAPD at that time. She knows a lot more, but obviously I want to limit it and can make it more concise. She could tell you a lot about the LAPD, and she doesn't make it just a few officers. She says there's many more than everybody wants to admit, and I don't plan to go very far afield, but I'd like to limit it to the things I've talked about here.
All right, Ms. Lewis?
Your Honor, that made me smile when Mr. Cochran said he wanted to limit it to what he had just discussed, which was everything in the book he could possibly hope to elicit from any officer. Your Honor, Sherry Ray was assigned to West LA Division for 3 years, 1985 to 1988. During that time, she told me today that she partnered at most, and she indicated that it was a generous estimate, at most 10 times with Mark Furman, because according to her, he worked the SPEW unit regularly and she did not work the SPEW unit. During that time, she indicates she recalls him using the N-word, but she doesn't recall any particular time that he did so. She specifically told me that he did not say, it's time to, pencil, fuck, and N-word. She cannot say that Mark Furman said that because she has no recollection of him individually saying that. She has a recollection, to her way of thinking, of various officers at West LA Division using racial epithets, and she has no specific recollection of any particular occasion or Mark Furman using them. So the defense proffer is based on someone who admittedly has a very shaky recollection with regard to Mark Furman's particular use, and admittedly had very little contact with him during what is a remote time period. And we're talking again about the 1985 to 1988 period, which is with regard to which the court has allowed abundant impeachment evidence. We have Laura McKinney's testimony that he used the N-word 42 times from 1985 to 1988. We have him saying it in his own voice, the best impeachment evidence the defense could ever hope to have admitted in a trial, the court admitted. We have Natalie Singer saying there's no good in like a dead end, highly inflammatory and prejudicial to the people's case, I submit. A statement of his that he made apparently back in 1987. Roderick Hodge testifying that he addressed him as an in January 1987. So we have all of these witnesses who have already extensively impeached Mark Furman on his use of the N-word. This witness adds nothing to that. It does not matter that she's a police officer. What they've done is put on extrinsic evidence that already impeaches him extensively on his use of the word, and now through Roderick Hodge, his addressing someone of the word. There is nothing this person adds that is probative on the impeachment issue, the very narrow issue that this court ruled was relevant for this impeachment to come in. Just because she's a police officer doesn't make her testimony any more probative on this issue. In fact, according to the defense, it would be less probative on this issue because of this conspiracy thing of theirs. At any rate, this woman's only knowledge of West LA Division, of LAPD, and of Mark Furman is 1985 to 1988. She's never seen him since then, except she did indicate to me that because she's been out from the department on stress leave, has watched the trial coverage extensively, including his preliminary hearing testimony last year, his trial testimony in March, the what I'll call Furman McKinney tapes 402 hearing held before Your Honor, and all of the Furman witnesses who testified during the defense case. She's watched all of that. But her only personal knowledge as to anything said by Mark Furman dates back to 1988 at the latest, and she has very little recollection of it. There's nothing that her testimony can add at this point of time that isn't, almost as a matter of law, unduly prejudicial to the people, because it's the cumulative effect of this stuff is geometrically increased with every witness, and the last ones who testified did give it that extra inflammatory edge which could very well, and indeed I believe has, caused at least some members of this jury to think far afield from the evidence in this case and to go far afield from the evidence in this case. We've demonstrated over and over again that no matter how many times this man used the N-word, no matter how bad a racist he is, there is no evidence that he had any opportunity to plant any evidence in this case or to falsify anything in this case or to do anything wrong in this case. So for the defense to attempt yet again to put on cumulative additional evidence on this point just to further inflame the jury now that there's been a little period of time between all the last witnesses and this witness they want to call now is simply not right, Your Honor. This is what 352 was enacted for, this exact type of prejudice. And here it's clear that there can be no additional probative value to be gained that could possibly outweigh the prejudicial effect. Here's just a couple of points. Mr. Cochran's offer of proof with regard to his speaking to her as a female officer, there's no relevance to Mark Furman's attitude toward female officers in this case. There's just no probative value there whatsoever, but to inflame the predominantly female jury that we have. So, Your Honor, that's it. Clearly, her testimony would be cumulative to all the other witnesses who've already preceded her on this identical issue.
Two quick points, Your Honor. Thank you, Ms. Lewis. The statement, the reason why I mentioned the statement with regard to the cover-up and the treatment of female officers, it corroborates exactly what Ms. McKinney said. Recall that a question was asked Ms. McKinney with regard to the cover-up issue, and the court limited us to cover-up vis-a-vis women officers versus men officers. It's entirely corroborative, and although they say that they gave up on McKinney, they didn't. They cross-examined her, they questioned her vigorously with regard, and I think it becomes very, very relevant. I also neglected to mention that she indicated to me that he did harbor a racial animus toward interracial couples. I mean, she does, in fact, buttress the other witnesses on various points, so whether Kathleen Bell or our Natalie Singer or whatever. It's not cumulative because, and the thing that's so relevant about this is a police officer, Judge. You know, how many times in a case are we going to be able to get a police officer who comes in and will tell us about this code of silence, or these officers test to lie, or that internal affairs doesn't do their job? And there's a number of officers out there that are doing this thing over and over again. This is a police officer who is saying that. Now, I think that's very, very important in a case where we've said these things do in fact exist. There are many people who don't believe these things exist. And you know the problem we have establishing this. Miss Sherry Lewis stands up here now and says that, oh, there's no way he could have planted this glove. We're going to demonstrate to this jury he had plenty of time to plant this glove. We're going to demonstrate when and exactly when he could have done it, and that he has a willingness to fabricate, and that not only could he have done it, he did it in this case. So that's just rhetoric. I'm telling you what we expect to prove to this jury. And so this is why this is so relevant to us. I mean, I'm not telling you I want to call 5 or 6 other witnesses. This is a police officer in a different category that I think, and I told you everything she could possibly testify with regard to the racial animus, the use of the N-word, the attitude toward female officers, the attitude of the cover-up. That incident on December 1988 was particularly chilling to her. And it buttresses exactly what McKinney said in her testimony here. So it's very relevant. It's not cumulative. And this idea that this is so prejudicial to these jurors is an insult to these jurors. They've seen and heard everything in this case. They're going to be able to sift through this. And I think we have to also balance this with Mr. Simpson's right to a fair trial. The people have objected to every witness we've called during the course of our case. This is just another objection, and I would ask the court to allow us to call this lady. There's one other aspect of her testimony I would like to bring to the court's attention with regard to a 402 that I'd like to bring also at some point.
One other aspect? Well,
Yeah.
we might as well deal with it now.
Okay. She has pending a matter in Orange County, Your Honor. She has a lawyer here, and it has no relevance at all to this case. And it's a matter involving a child custody matter, and I don't see any basis for that at all. I understood, and also Ms. Lewis, I understand when talked to her about a Board of Rights hearing. I don't think you can get into the Board of Rights or this other matter that's pending in Orange County. There's no convictions or anything of that nature. So I want a 402 with regard to that also.
All right, let's list those 2 last issues that Mr. Cochran raises.
Okay, and the last one first. Apparently, she does have felony charges pending in Orange County. Trial, according to her counsel, is set as 0 of 10 on October 16th. Clearly, if that's not a conviction yet, I don't believe we could impeach with that, though frankly, my co-counsel aren't aware of that. I'd like an opportunity to talk to them, and because there may be something that would be appropriate to bring up with regard to that. And I don't want to be foreclosed from that just because we've gotten discovery at the last second and been forced to argue this at the last second before Your Honor. With regard to one thing, yeah, that's, in fact, I'm just getting advice that it could very well be relevant, certainly to our bias and her reason for now saying these things when she did not come forth, to anyone in March, even though she heard Mark Furman's testimony and claims that he knew that was not true. Conspiracy and aiding and abetting child stealing, basically having to do with her grandson, I believe, her grandchild. While they're serious felony charges, I'm sure she doesn't consider them nothing, and there are serious conduct at issue.
So having conducted jury trials as to those issues before, I'm quite well aware of how volatile those are.
Yeah, very emotional and volatile type of situation. In addition, Your Honor, this Officer Ray is not saying, cannot say, and does not say, and is not saying that Mark Furman ever planted evidence, ever falsified reports, ever manufactured probable cause, or that she ever heard anyone else.
This was the only thing I was asking you to address were the pending charges and the border rights issue. That's the only new issue that Mr. Cochran's brought up that I'm interested in.
Well, Your Honor, these are serious charges that are pending against her, and the department apparently has stuff for which they have disciplined her, as well as additional stuff which is pending, and I'm not exactly sure of the nature of it. But that type of thing can certainly go to her bias. Whether or not we even would choose to attack her credibility is an issue that hasn't even been addressed yet, because we've only just recently gotten discovery on this woman and just, become aware. And none of us have had an opportunity to confer since the court has been in session with most of the lead trial lawyers on the case throughout the day. But it's clear that there are issues that would be raised, and we would not necessarily go without cross-examination. This is far afield, Your Honor. And as far as corroboration of Ms. McKinney's testimony, does the court even want to consider that? That is so far afield, the fact that she may have testified with regard to a sexist or a female attitude, to have this corroborate that when that had nothing to do with anything. We're not denying that he used the N-word 42 times. It's on tape most of the time, and it seems to be the truth, and we're not seeking to dispute that that is the truth.
Thank you, counsel.
Thank you.
Your Honor, could I add to the court's at
I'm sorry. No, this is as to the 402 issue as to Sherry Ray.
No, I just wanted to add one other thing when you have an
sorry.
opportunity on Mr. Marks as a witness. And his availability.
No, you're disrupting my chain of thought here. I'm about to rule on an issue, Mr.
I'm sorry.
Kelberg. Wasn't that apparent to you?
I wasn't certain whether the court had heard the argument and was satisfied now that it will be in a position to rule, or it was moving on to something else. I apologize to the court.
Let me think. Where was I? Do I need to hear the argument again? Never mind. No. No. All right. The objection is sustained for these reasons. I find the argument regarding the necessity of corroboration to have no merit. The racial animus of Detective Furman was corroborated by multiple witnesses who testified to the same thing. Also, his voice is on the tape, where that is abundantly apparent. There's no factual dispute that's even plausible at this point. It's a collateral issue. The proffer is remote, going to 85 to 88. It is clearly cumulative. The objection is sustained. All right, Mr. Kelberg, what was so important?
I'm sorry, Your Honor. It is only procedurally important. If the defense is contending that Mr. Martz should be called as a witness before the court rules on the admissibility of Dr. Whitehurst's testimony, the people say that that is an incorrect position. That, in fact, number one, the court limited the defense in their case in chief to Whitehurst.
Well, Mr. Kelberg, let's not even waste our time with this argument for this reason. If Special Agent Martz is in Washington, D.C. as we speak, and if we're not even going to get the Whitehurst documents in toto until sometime tomorrow afternoon, and we won't even be able to go into what relevance this might have at this point,
I agree, Your Honor, but
I'm not interested in hearing about Agent Martz at this time, only that I would ask that you make arrangements to put him on call so that he's available.
He already is.
All right. So he will be available on 1 day's notice.
I assume 1 day, obviously he comes from the east, and as long as we can make flight arrangements to get him in here on the day, but he is cooperative. The attorney for the FBI is cooperative. We just have to notify the attorney that he is needed on a particular day, and he will be here. I'm sorry that I caused such a headache.
All right, next issue. All right, what purpose are we going to recall Detective Van Adder?
I think that Mr. Shapiro is going to be handling that. He's got further questions of, based upon newly discovered evidence. He has further questions of Detective Van Adder on cross-examination. He's still a witness in this case, and we have not rested. I think we can do that. I mean, this is obviously, Your Honor, in this so-called search for truth, I would think that we certainly would have an absolute right to do that. The court is aware of this information. We expect to use it. I think it's our absolute right to recall him for this. He's the lead detective in this case. And are they saying they're not going to make him available to us? You're going to hide behind some kind of...
Oh, he's available.
All right, thank you.
He'll be available.
Okay, thank you. We'd like him tomorrow morning. Please,
But I
he's going to call Sherry.
understand there's going to be there'll be a request for an offer of proof, et cetera, so we'll go through this.
We'll be glad to give him that. But so we don't waste any time, since I can no longer call Sherry Ray tomorrow morning. I'd like to have him here.
It will necessitate.
Okay,
Well, that's been true with every witness, Your Honor, so we expect it.
all right. Tomorrow morning, 9 o'clock.
I just wanted to point out also that the defense indicated they wanted to recall Gary Sims, and we looked at each other in wonderment as to what that was about. I believe he was just here. if I'm not
Refresh my
mistaken.
recollection, why did we want to call Sims back? I recall that he was released subject to recall.
Yes, Your Honor. As you recall, you reviewed this material in chambers, that Mr. Sims has notes that on July 17th and on prior occasions, he observed a wet transfer in the second sock that goes from surface 1 to surface 3 in areas where there is blood that he did DNA typing, which is consistent with Nicole Brown Simpson. So, once again, the absence, the wet transfer through from side 1 to surface 1 to surface 3.
Are we talking on the second sock?
Second sock.
Is there a reason we didn't do this when he was here the last time?
Well, because on July 17th, when Dr. DeForest and Gary Sims did their re-examination of the socks, they documented this. This was the Brady material that you reviewed and Mr. Hodgman showed you. I realized it was confusing because they gave you unlabeled pictures for the longest period of time. But I think that's pretty clear. Obviously, if the same transfer mechanisms existed on the second sock that did on the first, that goes substantially towards the defense theory as to how blood was planted on the socks.
All right, here's the confusion that I have, Mr. Scheck, as to that issue. Wasn't Mr. Sims just here, and wasn't that information already given to you prior to that?
I asked to if you recall, I asked to make him my own witness, and the people objected.
You said we're going to be back here.
That's right.
And then you
I
said,
recollect. Okay.
we have to recall him. Now, what I would do, perhaps, if they want, is I will call Mr. Sims this evening at his home, and if we can work out a stipulation to the prosecution as to what his testimony would be, and we could write that out, that might save us all some
Okay,
time.
I do recollect at this point that there was an objection to going into those areas on the scope objection. Ms. Clark?
Yes, if I could be heard on this one, Your Honor. First of all, this would not, as I understand it, be proper rebuttal, because we presented nothing in rebuttal that goes to this issue. That's first of all. And I think that one's clear factually as a matter of record. Secondly, that means that it should have been presented in their case in chief. And the stain that they're talking about was observed by Henry Lee and by Mr. McDonald. Why they did not elicit the testimony from those people, I do not know. But they indicated that they were going to rest conditionally upon the court's determination of the admissibility of the Whitehurst issue. and nothing else. And we asked the court specifically if they were limited in their conditional reopening to that issue, and the court indicated that it did.
All right.
Now, with respect to
Hold on. Okay, what we'll do is, Mr. Scheck, Mr. Neufeld, put it in writing what it is you want to present and why it wasn't presented earlier. All right?
Your Honor, there's one other item.
Yes.
You may recall that when
Is that
Mr.
a candy bar wrapper?
Well, no, it's a syringe wrapper.
Okay.
On April 11th, 1995, when I, in the company of Joellen and Demetrius and Bob Blazier, interviewed the nurse, Mr. Paratus, at the infirmary at the police department headquarters, we asked him which syringe he used to draw blood from Mr. Simpson on June 13th. And he opened the drawer and he showed us a syringe. And he gave us all the specs on the syringe. And it's a Becton Dickinson 10 cc syringe with the calibrations right on it. We went out and we purchased these with the hope of obviously introducing them when he took the witness stand. He's not taking the witness stand, as you know. He had these same syringes with him when he did the demonstration for Mr. Goldberg. However, you can't see the actual syringe in frame. I mean, you know it's a needle, but you can't see the calibrations because the syringe is being held too far away.
Well, let me jump way ahead of you, Mr. Neufeld. What you want to do is introduce that syringe in front of the jury. So we can do this one of two ways. Either the prosecution can stipulate that that's the syringe that is in use at the Parker Center Infirmary, or you'll have to get somebody from Parker Center to come over and say, this is the syringe we use.
Well, just so you know where we stand on this, I already gave one of these to Mr. Goldberg with the hope that he would agree to a stipulation. Otherwise, what I might have to do is, I want to avoid calling either Mr. Goldberg or Mr. Blazier, because they were the ones who were actually there and know what he said. Now, it may be that they're using different syringes now at Parker Center. I don't know the answer to that question. But the easiest thing would be simply to stipulate, and otherwise you will have to call additional witnesses. You're right. And I want to avoid that. That's all.
But see, here's the problem. As a matter of evidence, how do you propose to do that by other people's statements?
Well, no, I can call, one thing I could do, if I can't get the stipulation, is I would call, first of all, I could call Hank Goldberg as to what kind of syringe Mr. Paratus was using in that demonstration he did on July 27th at his house.
Not necessary. You can call Oppler.
No, Oppler won't know the syringe, I'm afraid. And I already asked Ms. I think her name was Ramirez, whether she remembered it, and she didn't. So they don't have the specs on it. Mr. Goldberg was the person who had frequent conversations with Mr. Paratus, and would be the person who, did this with him that day, frankly. He directed it.
As a matter of hearsay, contemplate how you're going to do that. All right. I would suggest try to stipulate first, and if not, call somebody from the infirmary as to what's in stock. Because that's B&D is a standard medical supply.
Oh, no. But what I'm explaining is that they actually, is that Mr. Paratus showed us the packaging so we know which model number and everything else. And this is, in fact, an exact duplicate of the needle of the syringe described by Mr. Paratus.
All right, well, maybe I'm not making myself clear at this point. Okay, we'll be in recess 9 o'clock tomorrow morning. Thank you all.
You got those witnesses, Judge? So I want to, here we go.
I'm sorry?
You got those witnesses, the Gallagher brothers, Dale Davidson, Wax.